You have been served with a copy of section 5.
Yes, fine. Yes.
যদি delay, যদি consent delay condone করে দেওয়া
And on previous occasion, there was a direction for appointing the advocate of from the legal aid, my lord.
Yes.
স্বরূপ দাস। স্বরূপ দাস কে রে? আমাদের এখানকার
ইঞ্জিনের delay হয়েছে।
ও আচ্ছা, সুভাষের জুনিয়র ছিল। সুভাষের জুনিয়র ছিল।
Where is your application for condonation?
It is hearing 1 of 2024. হ্যাঁ, এ তো petitioner নেই, appellant নেই।
You are for the state.
I'm for the state, man.
Then who is for the petition?
স্বরূপ দাস,
Then how can
recorded
we
advocate.
let him appear? Otherwise,
My
how
lord,
can
ইঞ্জিনের delay আছে। সে appear তো করবে, বলবে তাই না। তাহলে তো লিখতে হবে non appear করে তারপর
or we pass it over if he comes?
My
We will
lord,
take
my
it. Yes.
Number 2, Lordship, in item number 2 and 3,
Hmm.
I am appearing for the Deepam Singh, the accused. Lordship, the section 5 application and the bail application not yet been affirmed actually, only because it's a legal aid matter. The paralegal volunteer has already been appointed. She is coming today. Let the matter come up on next Thursday. It will be on list.
This Thursday it will be
Lordship,
okay.
obviously, she will come on today at 1 o'clock. একদম আজকে বলি।
তো এটা Thursday রেখে দিন।
Grateful. 2 and 3 both.
2 and 3 arising out of the same judgment.
Same judge. One is filed by the, one is JLP, one is filed by myself from the Gazette.
এটা হলো legal aid এর content হচ্ছে, ওটা ওখান থেকে state পাঠিয়ে দিয়েছে। এত কিছু ইয়ে দিয়ে যে কোনো একটা যেটা এখন তো বেল ম্যাটার আর ওই সেকশন 5 এ দিল।
Yes.
Item number 3.
Item 3 তো হয়ে গেল।
Item number 4, I am for the state, my lord. This is a appeal against acquittal, my lord.
What is the defect?
Even, my lord, 38 days delay, my lord.
Have you
Just
served
granted to other-
completed service?
No, my lord.
Section 5?
They said, no, that's right.
To complete it, we will take it up on Thursday.
My lord, petition is not. Appellant is not.
No, your application, section 5.
State.
Oh, you are for this?
Yes, my lord.
You have got the section 5 application?
No.
You haven't got it?
No.
Thursday রেখে দিও, বলে দিতে।
Direction to serve.
Let it be on Thursday. Who is entering afference, you can, I think if you get the service within that time, we can dispose it of on that day.
Bhaskar, yes, my lord.
Please ascertain from Mr. Chakut, please ascertain, take a copy, we will dispose it on Thursday. Yes, Thursday.
এটা থাকতে ভাস্কর রায়ের সাথে একটা না ভাস্কর
ওই যেটা পাস ওভার করলাম ওটাও Thursday রেখে দিতে হবে। কতক্ষণ রাখবে না? আচ্ছা থাকো, পরেরটা দেখো।
Praying for a short Passover, your lordship. My learned counsel is on the way, your lordship.
পাস ওভার, yes.
I কি অ্যাপ্লাই করতে স্টেটের জন্য।
You are there for the state in 5.
Item 5.
No, man.
Then pass over. Mr. Bhomik, can you give us that copy of the order you showed? We want to check up one thing.
No, I have already had it.
Oh, that's in the file.
I have also mentioned in my appeal. I've also mentioned in my appeal, I've annexed the copy of the order in the appeal, memo of appeal.
আচ্ছা, all right, ঠিক আছে, ছেড়ে দাও।
Already I have handed over a single copy and
Yes, next,
Item number 6.
Thursday রেখে দাও।
Item number 7.
now for the appeal.
Yes,
For the statement.
But this is a legal aid service matter, my lord. There is a delay of 141 days. That may be condoned, my lord.
পক্সো,
Poxo, my lord.
upon hearing the learned advocates appearing for, Mr. Chakraborty, you are there.
But
Upon hearing the learned advocates appearing for the respective parties and considering the materials on record, the delay in preferring the appeal is condoned. We are satisfied, here consider materials on record, comma, we are satisfied with the explanation given towards the delay in preferring the appeal. Stop. Next para, accordingly, comma, the application for condonation of delay being
Can one, my lord.
CRAN,
CRAN.
they can, CRAN 1 is disposed of. Stop, the appeal is admitted. Next para, call for the records. Next, issue usual notices. Stop. Liberty is granted to the appellant to apply for bail upon notice to the state through the learned public prosecutor. Are you intending to file any appeal?
My lord.
Huh? তাই বলে দিন।
Liberty is granted to move, file bail.
Public prosecutor, comma, High Court, comma, Calcutta. No, to the public prosecutor.
What?
Stop. To the learned public prosecutor. Stop. Next, paper books be prepared within 4 weeks
My lord, as well.
from the date of receipt of the lower court records.
Gratefully, your lord.
Great. Item number 8.
এটাই করেছি আজকে। লিখেও দিয়েছি appeal।
Yes, sir.
8 minute, I am for the appeal, the admission stage minute.
Delay is there?
No.
No delay. আচ্ছা, আগেরটাতে ক্র্যানটা তো লিস্টে নেই, ক্র্যানটা আছে। হ্যাঁ। ও
কোথায় আমি ঠিক
it is within time.
Yes.
Effective date নেই যখন time নেই।
Stop, the appeal is admitted. Stop, call for the records. Stop, issue usual notices. Stop. Pending, stop, liberty is granted to the appellant, na appellants দেখে নিই। Appellant to apply for bail upon notice to the state through the learned public prosecutor. Stop, paper books be prepared within 4 weeks from the date of receipt of the lower court records.
With in the item 6 minute.
6, what happened?
This is a delay application minute for
Mr. Chakraborty was there, 6.
I have already.
What did it we passed it over? Huh?
6.
Yes, it is fixed on Thursday.
Thursday.
Who is your other side? You know?
Yes,
Mr. Chakraborty, please call Mr. Chakraborty. Any section 5?
yes.
How many days delay?
633. 633. Yes.
They filed 633.
633.
Yes,
That means more than 2 years.
more than 2 years.
Oh,
Legal service matter, legal age matter. I have-
The person is in custody
Yes,
actually.
yes. But 10 years not punished. For
Which section?
376, 417, promise to marry.
দেখি consent দিলে পড়ে যাবো এটা
তাহলে করো।
legal aid এর matter বলছে।
legal aid matter? Right. Yes, somebody sent for Mr. Chakraborty. Is anybody here?
Yeah, no one is the application for convention of delay.
Have you given copies, hard
Yes,
copies?
yes, this is affidavit service.
4 বছর কাস্টডিতে আছে আর কি।
হ্যাঁ দুটো আছে।
Yes,
Six,
the condonation of delay matter.
But what have you stated here on 11th? No. The 6th. What is your explanation, sir? Where you have written?
Explanation, my lord. Kindly see
Where
paragraph
is,
paragraph 4, my lord.
4.
what do you
and
say,
five.
Mr. Chakraborty?
A copy.
হ্যাঁ দিয়েছি সার্ভ হয়েছে। ওই যে,
692 is delay.
ওই নিয়ার অফ বছরের মতো ডিলে আছে।
paragraph 4 and 5 I expect.
Easy to say section of the criminal to different approaches to civil.
Yes, Mr. Chakraborty, have you seen that?
Yes, for financial crisis is not.
Legal it. Ashok. Drawing our attention to the amendments made in paragraph 4 of the application for condonation of delay, Mr. Kundu learned advocate appearing for the appellant submits
হ্যাঁ দিলে।
that the delay which has occurred is neither Mr. Submits that the delay which has occurred is neither deliberate, is not deliberate. Stop. The appellant was under extreme financial crisis, and he had to approach the legal.
May I?
He had to approach the Legal Services Committee, High Court, for preferring the present appeal. Stop. Mr. Chakraborty learned enters appearance on behalf, learned public prosecutor, na? Enters appearance on behalf of the state. Stop. Upon hearing the learned advocates appearing for the respective parties and considering the materials on record, we are satisfied with the explanation given towards the delay in preferring the appeal. Accordingly, such delay is condoned and the application being such and such is disposed of. Next, the appeal is admitted. Stop. Call for the records. Stop. Issue usual notices. Stop. Liberty is granted to the appellant to apply for bail upon notice to the state through the learned public prosecutor. Stop. Paper books be prepared within 4 weeks from the date of receipt of the lower court records. Yes, next.
Item number 9.
Lordship, I represent the state in this matter. Lordship, there was a direction for filing of paper books.
Has it been done?
No. No, Lordship. Next appeal.
When is the next circuit?
Probably from the fifth, Lordship.
Yes, how much time do you want?
Mr. Nishat, may I
Pardon?
take it? Next circuit.
The learned advocate appearing for the appellant prays for extension of time to file the informal paper books. Stop. Such prayer is considered and allowed. Stop. Let the informal paper books be filed within a week after the vacation. Stop. List the matter before the next available circuit bench.
Lordship, state is represented.
Yes. ওনার নামটা দিয়ে দিন।
Grateful.
Number 11.
Yes, Lordship, I on behalf of the appellant, Lordship, there is a defect, Lordship. I want to file the condemnation of delay, Lordship, section 5, Lordship. That is not filed, Lordship. I have sent to the department to vetting, Lordship, and till then not filed, Lordship. Yet to be filed, Lordship. Finally, 2 weeks time to file the condemnation of delay and a stay application.
The learned advocate appearing for the appellant prays for an adjournment to take appropriate steps in the present appeal. Stop. In view thereof, list the matter for further consideration before the next available circuit bench. Yes, next.
Number 12.
Lordship, in this matter, there was a direction to file report, reply, Lordship, if it is in opposition.
আচ্ছা দেখি ফাইলটা দাও।
Finally, be time to extend file the reply, Lordship. We already prepared, Lordship, and
It's a
sent-
small matter, sir, you
Yes,
can do it.
We're setting for vetting, Lordship, but
The learned advocate appearing for the appellants prays for extension of time to file the affidavit in reply. Stop. Such prayer is considered and allowed. Stop. Let such affidavit in reply be filed within a week after the vacation. Stop. List the matter before the next available circuit bench.
yes,
Here a password which owner 5 বলো। কি করেছি ওটা 5টা?
My lord, in item number 5, there is a.
Just next Friday করেছি না কেন আছে? Yes, what is the problem?
My lord, there is a defect in item number 5.
Huh?
My lord, previously,
What
Yeah.
defect?
As condonation of delay.
File that
previously,
application.
There was a defect. It should be, it should have.
What was shown yesterday, the combination of duties. In the erstwhile division bench, the defect was shown as 52 days, whereas we have written 51 days. So we have pressed for a liberty to, we have asked for a liberty to not press the application and file afresh as to subject it to constitutional delay. We went to the department. They have even stated that they have taken a wrong calculation in the erstwhile bench. It should be 32 days. So we have accordingly with the instruction of the department, we have made it as 32 days with the new CRAN application.
Who is your others? You have filed 2 CRAN.
Yes, one CRAN was not pressed as to the wrong continuation of delay.
So that was the order given, not pressed.
Yes.
When was that?
It was given by the erstwhile division bench.
Not pressed means that has to be recorded, na? Then where is that recording that it hasn't been not pressed with liberty to file afresh?
The last paragraph.
Yes, sir.
Yes.
Acha, who is your other side?
My lord, it's admission of appeal, my lord.
Right, state is appearing.
No, my lord, because it is not yet admitted, the appeal.
No,
is
no,
not yet admitted.
CRN 1 is dismissed
Yes,
with liberty to afresh.
yes,
So you have filed another CRAN.
Yes.
Where is that?
my lord, it's already.
What is the number of that? CRAN 2.
CRAN
Have you
2.
served it?
No, my lord,
Who, call Mr. Chakraborty.
very good.
এইমাত্র বেরিয়ে গেল।
So how many days delay ultimately?
My lord, ultimately department has stated that it is a delay of 32 days.
So
we-
what explanation have you given?
My lord, puja vacation, flood, There's a recent flood in the hilly areas and the barge strike, my lords.
ক্ষেত্রে তো একদম অসুবিধাতেই
না, condemnation ও নেই তো সে।
বক্তব্যটা রেকর্ড করে পাওয়া
Let Mr. Chakraborty come.
Is it to the Passover minutes for Passover?
Is he there?
Chakraborty or his junior can also.
Passover, call him.
Very
He told of him
short,
to come.
short Passover.
Yes, next. You have taken it to down.
Number 13, number 14.
দেখি ফাইলটা দাও। কি আসছে? কেউ আছে নাকি?
একদম 14.
My lords, am I audible?
Yes, yes.
My lords, on item number 14 is the income tax matter, GST matter between petitioner and the state of West Bengal. But the honorable bench that presided this bench was of the opinion that union should appear and make its submission. So, my lord, I represent union, though we are not a formally made party, but the petitioner, I guess, is not before your lordship, neither the state.
Not today, tomorrow.
All right, we keep it on Thursday. Let us see you. You will be okay on Thursday?
Lordship, Thursday is 19th.
Check it up.
My lord, kindly fixes it on Monday because the council will be coming from Calcutta.
Not this week.
Not this week.
Grateful, lordship, grateful.
Item number 16.
Can one আছে দুটো।
কিছু পরের পরে adjournment minutes.
one আছে স্যার দুটো।
Application গুলো কি গো?
Section 5 to mention. আজকে থাকে
Thursday করে দাও। এদের কি আছে এটাকে বলো?
এই
কাগজটা পুড়ে গেছে। কি আছে?
Number 17.
Milord, I am for the appellant, Milord.
Yes, sir.
This is regarding this, I was delayed for 16 days to file the appeal.
Have you served?
Yes, Milord.
Who is your other side?
No, at first, I think you want to consult.
Who is the advocate of the thing?
Uh,
Where is your service?
Milord, this is a state matter. I've just filed completed.
So state is not required to file an affidavit of
At
service.
first, Milord, you'll have to consider this fact. Thereafter, your lordship court will direct the serve the copy.
Under
After that,
which law, sir? That a section 5 application court if feels then service is to be effected. It is your obligation to serve.
So I'll come back tomorrow, my lord.
It will take some time. Day after tomorrow.
ষোলো দিনের delay বলছে।
Just 16 days, my lord. Poor widow, my lord, she has to come from Tode, my lord. And during this rainy season, as well as she's poor lady, no source of
Now, very
income.
good, but this application have you served upon the respondent?
No, I'll come back, my lord, tomorrow. I'll inquire my clerk, my lord. Grateful.
Monday. Yes. Complete service in the meantime. Complete service and come.
Item number 18.
Lordship, I am for the respondent number 8.
For the state.
I have been directed to file affidavit in opposition.
To the stay application.
There was a direction to file.
Direction to file.
The stay application as well as to the. main application.
Can application.
No, is there any delay?
But that has already been.
No, that has already been
Allowed.
admitted.
No, where it is happening?
Last,
Last-
28th November.
It's within time.
We are not saying that. We are saying that what are the two applications you have filed?
No, we have not filed.
You are the respondent.
I'm the respondent.
the state respondent is the private.
One is for a stay.
Over there.
You know, my lord. Have you served?
Yes, that's fine.
Yes, they have
On
served.
last occasion, there was a direction. Time was given them
Just some.
to file the.
One application is for adducing additional evidence, another application is stay application. Can one agree is stay application?
So you have not filed opposition.
Only I pay
Can't
for extension for 2 days. And
You are for whom?
respondent number 8.
The learned advocates appearing for the state and the respondent number 8 pray for extension of time to file the affidavit in opposition. So such prayer is considered and allowed. Let such affidavit in opposition be filed within a week from date. Reply thereto if any be within a week. Reply thereto if any be filed 1 week after the vacation or on the reopen.
Lordship, make this order peremptory because our.
Reply affidavit. Reply if any be filed by 2nd January 2026. Establish the matter before the next available certificates.
Grateful, Lord.
Number 19.
19, I beg to appear on with the state, my lord. In this matter be taken up on Thursday, my lord, because we have to take instruction. As because pursuant to the single bench order, there was a direction upon the respondent authorities to approach the Heritage Commission. To approach the Heritage Commission and seek the opinion, my lord. So whether that opinion has reached or not, we have to come with that instruction, my lord.
But I am for the appellant, my lords. I am aggrieved by an order passed by the Honorable Single Judge. The order is there with the memo of appeal.
Was it hard earlier?
This is the first occasion it is appearing before. There is a can for appropriate order. It is filed within time.
I see. You have given copies to the.
Everything is also.
You're there.
Thursday, my lord.
No, do you?
And I'm led by Additional Advocate General also in this matter, my lord. My lord.
If I can have also
No,
very briefly on the facts of the case, my lords. This, my lords.
Tender matter.
Tender matter.
Work order issued.
Work order, my lords, there is a stay, but they might issue it at any point of time.
Stay by this.
By the writ court.
Huh?
By the writ court.
By the writ court.
By the writ.
Till the opinion
They have-
reaches.
They have till the.
Opinion reaches from the Heritage Commission.
Because the
Decision
order
is
is
appealed.
the order.
The order is there with the memo of appeal. It is dated 24th of November 2025.
The writ petition is pending.
No, my lords, it has been disposed of. With certain direction, I will take my lordship to that.
Interim order granted.
And then if I can have my lordship for a moment on the facts of the case. As to why I am aggrieved by this order.
Judge, give us 2 minutes.
My lordship, I'm so sorry.
Why you are aggrieved, sir?
My lordship, if I can have my lord for a moment on page 36. To
So
begin with
you
of
are
the
saying
can
this
application.
report, this consultation is not yet over?
My lord, that I have to take instruction. We have not yet received that instruction, my lord. Unless that is available, I cannot submit, my lord.
But unless you act speedily, the entire
Yes,
project
it has
is
been
stalled.
forwarded to the Heritage Commission.
Acha, so how many bidders were there apart from you?
Two bidders.
Only
No,
two
there are including the bidders.
Including
In
the
the
petition.
first call, this was the third call, my lords. In the first call, only the private respondent was the bidder. Now,
I
because
see.
the minimum quorum was not there, therefore there has to be a second call that was called for.
Very good.
In the second call also, my lords, there was only one bidder. So the minimum bidder, the private respondent,
Again that failed. Now third call.
it did not fail because of minimum quorum, but it failed because of other reason, because the private respondent didn't have the required credential. Then comes the third call. In the third call, my lords, I also participate along with the private respondent.
Two private respondents.
So writ petitioner and a private respondent. So total number of bidder was 2.
Very good.
During the technical round, this is a 2-bid process. So for the technical has to happen, and then from the qualified bidders, the financial has to happen.
Financial.
During the technical bid, my technical documents were disqualified. That was challenged before the writ court. During the pendency of the petition, the financial was also open. And because he was the only one bidder, the private respondent, therefore only his financials were open. At that point of time,
Now work order
has not been issued. Has not been issued.
Then how you can retract? What the court has said nothing about the second bidder who has already, whose financial bid has been opened.
In fact, what has happened is the court.
No, let us understand. I'm just.
I've explained.
No,
Actually,
if the financial bid has been opened.
Yes.
So then what remains, sir? Now, after opening a financial deed, he becomes the successful person, being the sole competent person. Due to pendency of this, his bid is being frustrated then.
No, my claim, is that my technical has been rejected in an arbitrary.
Right, your technical bid arbitrarily rejected. Court said that whether it has to be taken into account, whether you have conducted any work similar in nature or not. This was the issue. So it's sent to the appropriate authority for whom he is appearing.
No, my lord. The authority is not the appropriate authority. That's what the bone of contention is. If I can have my lordship for a moment on page 36 of the stay application.
No,
There is
Mr.
the NIT.
Mishro, if the second person's financial bid has been opened,
Yes, ma'am.
then what happens to the tender process?
The tender is stayed because of the order of the writ court. No, nothing further has been done.
Financial bid was opened prior to the order of this court. 24th
Yes,
November.
yes.
Then you have not made him a party.
No, the private respondent was always a party throughout.
So who is appearing for the private respondent?
Nobody has appeared for the private respondent.
No, just tell me one thing. Suppose today you are found fit.
Yes, then my financial will also be opened. And then whosoever is the lowest bidder will take the work order.
Open হয়ে গিয়ে ওকে ফ্রাস্ট্রেট করে দিয়ে এগুলো রেখে দিই।
Right, but,
কি করে হবে?
probably would have produced an involved very well.
না না টেন্ডার প্রসেস টেকনিক্যাল বিট ফিনান্সিয়াল টেকনিক্যাল বিটস তো যে এই ডিসপিউট এসছে কোর্ট সেটাতে ইন্টারফিয়ার করে না in the midst of the private respondent the finance he was technically qualified ওর ফিনান্সিয়াল বিট খুলে দিয়েছে হ্যাঁ এবার ওর যদি ফিনান্সিয়াল বিটটা তো ও জেনে গেল 5 টাকা দিয়েছে ও 5.5 টাকা দিয়ে নেবে
No, what happened is that during the tender process, the technical and the financial has to be submitted together in the portal. So,
Sir, whether tender process culminates into a finality with the opening of the financial bid.
with the issue of the work order.
Work order is a consequential step. Let us consider the tender process. It is initiated by submission of bid, culminated through opening of technical and financial bid. In your case, in the midst thereof, court has intervened. But the financial bid of the private respondent has
Because
been.
Even before the financial was
Yes, I am wanting to know. Suppose in the financial bid which has been opened, the authority, you also come to know that he has given 5 rupees. Now, ultimately, if you are found successful in this process, you will give 5 rupees. 50%.
Now I have to give. I have already given.
Oh, you have already given.
No, at the time of technical itself, the financial was uploaded.
So if we ascertain what had been your financial bid finished, if his financial bid is great or higher than.
Yes, that can be done. Let my financial be also open. If I have the lesser financial, then I will be given. Otherwise, I will not be given.
হয়েছে কিনা কতটাকা যদি দেখা যাচ্ছে যাকে দিচ্ছে প্রাইভেট রেসপন্ডেন্ট হচ্ছে বেশি
that will be pursued, the law will take it forward.
সেটা তো উনি বলেই দিচ্ছেন
Solicitor direct-
So Mr. Mishra, you have spoken sensibly. We will open that financial bid and come to know.
I have a reason why my lords
Let us
will.
come with the opinion first, my lord.
My lords, that is in my favor, but I have a reason why my lords will
Oh,
not do
that
so.
is in your favor. Oh,
I have
that
a
is
reason why
you
my
are
lords will not
laughing
do
so
so.
much.
And my lords, no, I need to be honest before the court. If I can have my lordship for a moment on page 36.
উনি যে জানে তো ওটা কথা।
No, because I now know what his rate is, because the financials has been opened.
But it is get out there.
I should be humble and candid before my lordship, my lords. That will not be
We
something.
are also humble and candid, sir.
That's something that my lords will do. If I can have my lords for a moment on page 36. What the problem is, I will explain in a nutshell.
No, then we listen it on that.
Thursday, ma'am. Rally.
Come with that report.
Yes,
We finish it off.
Well.
Heard Mr. Mistral and the advocate appearing for the appellate. You are for whom, sir?
For the state.
They are respondent 1 to 5.
Mr. Pal and the advocate appearing for the state respondents press for a short accommodation to avail necessary instruction. In view thereof, list the matter for further consideration under the same heading. Thursday or Monday?
Thursday, ma'am.
Sure.
Yes.
We will not adjourn.
My lord.
Thursday. All right.
I'm out.
Lordship, in item number 20.
Advocate টা যাবে। এই যে জীবনে জিনিয়ে রাখবো।
99%
Yes, sir.
In
Item 20.
Lordship, stand for the railway authority, your lordship. Matter is disposed of in 2023. Now one CAN application was filed, copy not served, so I am unable to. Why the copy?
Acha, acha, acha. Yes.
I have filed the CAN application, my lord, for substitution of the petitioner, my lord.
What
Because-
substitution?
my lord,
Proceeding
my lord,
ended.
There was an order of the writ court, my lord,
Division bench.
of our division bench, my lord,
Yes.
to consider the representation of the petitioner.
Where is
My lord, the order starts from page 53, my lord, of my CAN application.
Who was the employee?
The husband of the petitioner.
But the High Court order was between Pratima Sarkar and Union of India.
Now, my lord, Pratima Sarkar had filed.
Pratima was the wife of the deceased
Deceased
employee.
husband. Now,
So
my lord,
before the High Court heard the matter, that person expired.
No,
Pratima
Lord.
Sarkar expired.
Pardon?
My lord, Pratima Sarkar expired
After the order was passed.
after the order was passed. Now, my lord, this order was
Who
not.
was the employee?
Not the
Employee was Pratima's husband.
Pratima's husband.
What is his name?
But his name is Virendra Kumar Sarkar, my lord. My lord, find it at page
Shall be
60.
Acha. Oh, now Pratima has expired.
Prior to filing of the, my lord, now we seek to file a contempt application, my lord. My lord, that's because this order has not been complied with.
This order, Pratima was not called for a hearing after this.
My lord, she was called for a hearing, but the order passed, my lord, was not reasoned, my lord. The
Then
order,
that can be challenged if it is not.
You can
reasonable.
challenge that.
Yes.
So where is the scope of contempt?
What are you praying for in the application? Tell
for
us.
substitution of the petitioner, my lord.
Now, what purpose will be served?
My lord,
A
so that,
fresh order has been passed.
my lord,
You are aggrieved by that. That aggrieved means you are the daughter,
my lord, the son,
son.
my lord.
So that order, if that reasoned order, that is pertaining to the service condition of your father.
My lord.
So, sir, you
Hello.
will have how if the
আবার
reasoned order was passed
দুই আর
upon him,
18 নম্বরে অ্যাপিয়ার করবে
you were hurt by the authorities.
My lord, I was hurt by the authorities.
যদি order pass করে, so order টা চালু থেকে retrial করবে।
সেটা লাইভ করে ডেটটা দেখুন আমাদের। You have not been given a copy.
No, your lordship. But if the order of the honorable court was already decided, your lordship, representation consideration by the
Go
division.
through the application. We don't know also what
Lord,
has been
Lord.
written.
Lordship, a
I think
copy
the
may be
copy.
served upon us. We
I
will
should serve a
come
copy
up
and
with a
come.
reply.
You give a copy to him today so
Right.
that he can Monday we
Lord,
will take up.
Lord,
Great,
Lord.
sir.
Grateful, my lord.
Take a Monday. We are not passing an order. You just hand over him a copy
Lord,
so that
Lord.
we can take it up and come prepared. Yes.
My lord, one line order would have benefited us.
Online order.
Mr. Mojumdar wants to be benefited. What can be done?
Blessed by your lordship, brother.
What is your name, sir?
Lord, Mayank Roy.
Mayank?
Roy.
Goyal.
Roy. ROY.
Roy. Sorry. একটু ফাইলটা দাও। The service of the copy of Mr. Roy, learned advocate appearing for the petitioner submits that service of the application being can 2 of 2025 ও তো appear করে যাচ্ছে। না এরকম লেখো the present application can 1 or can 2?
Can 2 of 2025, your lord.
The present application being can 2 of 2025 has been filed in connection with the writ petition being WPCT number 4 of 2019. Heard Mr. Roy, learned advocate appearing for the petitioner, Mr. Mojumdar, learned DSG, appearing for Union of India, submits that no copy of the application has not yet been served upon him. In view thereof, list the matter for further consideration. Any private respondent? In the daily on Monday date the petitioner is directed to complete service in the meantime.
Great, sir.
Yes, pass over.
My
Mr. Chakraborty, you are there.
Yes, my lord.
চলো তাহলে ওই অর্ডারটা দিয়েছি করে দাও। দাও ফাইলটা দাও।
পাঁচ।
How many days delay?
32 days, man.
Upon hearing the learned advocates appearing for the respective parties and considering the materials on record, we are satisfied with the explanation given towards the delay in preferring the present appeal. Stop. Accordingly, such delay is condoned and the application being granted
Grant two.
of 2024 is disposed of. Stop. The appeal is admitted. Next para. Next, call for the records. Next, issue usual notices. Stop. Liberty is granted to the appellant or appellants.
Appellant, my lord.
Appellant to apply for bail upon notice to the state through the learned public prosecutor. Stop. Paper books be prepared. Next, paper books be prepared within 4 weeks from the date of receipt of the lower court records. Application disposed of, appeal admitted. ওই সেম অর্ডারই পান ইয়েকে নিয়ে রূপম একটু দেখে করে দিও। ইয়েস
Item number 21.
আপনার সাথে আমি বসেছিলাম কোন আছে
আগের বছর এপ্রিল 24 অরিজিৎ রাজ সাথে এই বসেছিলাম অরিজিৎ রাজ।
Yes. Yes, Mr. Kundu.
My peer is to reinstate my service as I was.
Uh-huh.
My peer is to reinstate my service as I was.
Reinstate.
Yes.
Why you have been terminated?
They says they had been terminated. No termination order was issued.
So any application filed?
No, application not filed.
What is opposition? You have
Opposition,
filed.
yes.
Where is your reply?
Reply is not necessary.
Sorry?
I have ready for
Uh-huh.
ready for it.
You don't want to file reply? Huh?
No.
Achha. So we'll record that. We will not file any. Don't say after hearing, then I will file a reply.
My lord, what's happened, my lord?
Uh-huh.
Petitioner is now seriously ill. Not that kindly see, my lord, the last tribunal order.
Achha. Show us.
Last page.
Here, rendered service. So I get a affidavit directly. If there is available vacancy, the same will be kept back. At interim protection right here. শুনে নিতে হবে শুনে সেটা ক্লিয়ার না যেতে পারে।
Yes, please.
Kindly see the order. As per notification of 2010, my lord. 2010, my lord, my service has been continued till 60 years, my lord, without any break, my lord. It is 2010 notification says that, my lord, but without giving opportunity.
Let us go through the order. Any order passed by this court?
Yes, my lord.
Admission
Yes.
stage, any order was
Yes.
passed? Where is that order?
যেটা দেখলাম
Ah, okay, yes.
30th August.
Tribunal dismissed your application.
No, not dismissed, my lord. Partly allow, partly rejected.
Where is the tribunal order?
The last page, last 3 pages.
13 December.
Yeah.
Have you brought Jaggo? Have you brought Jaggo and
Jaggo Milot, that is the
Dharamjit
Regula-
Singh, last judgment of.
regulation.
Huh.
No, I am not paying for regulation. I was engaged daily, daily casual worker, daily rate basis.
Wait, let us go through the order.
At least according to you, it is in violation of this memorandum.
Yes.
মেমোরান্ডামটা কত কত আছে?
Memorandum page 53.
Yes, Mr. Kundu.
First of all, Milot, if I am
No,
fulfilling
then by this order, you will grant part benefit.
part benefit,
That is tribunal directed to grant you remuneration from 1994
till 2017,
when you were terminated.
yeah, terminated, but not allowed to.
Alleged
Yes,
termination.
alleged term.
Now in 2017, what was your age?
2017, Milot, my age is Milot, 47.
So you
Now I am 53.
Now you're 50.
53 age, 53,
I see.
53. As per notification, as per
So
memorandum,
the tribunal said that you give him the benefits till her termination without adjudicating whether the termination was proper or not. That is your argument.
yes. And if I fulfill the criteria of memorandum,
Then I should be allowed to be
to
reinstated.
join daily rates as I was.
Show us, place what you are placing.
First, can you see page 53? 53 memorandum.
Page 53. State order চ্যালেঞ্জ করে স্টেট যদি যা চালে বেটার করে ও কি 17 যে স্যালারিটা তো দেবে ইন টার্মস অফ দি ট্রাইব্যুনাল ইটের প্রজেকশন জীবন এটা তো দেবে না আজকে আমি ডিসকাস Yes, sir, you have not challenged appeal against the order of the tribunal.
We are not challenged and
Then you are bound to pay that amount to the petitioner.
already paid.
Already paid?
Amount paid.
Amount is already paid.
Oh, I see.
Amount paid, my lord, I am paying for restate my service. As
সেটা পয়েন্ট নয় পয়েন্ট হচ্ছে ওয়েলফেয়ার মেনে সেটা বলতে না আমরা তো মেনে নিয়েছি ওকে ওকে 94 থেকে 2017 অব্দি বেনিফিট দিয়ে দিয়েছে এখন ওরা বলছে 2017 টার্মিনেশনটা ওয়াজ ব্যাড without any basis সেটা তো was not adjudicated upon by the tribunal
সরকারি ট্রাইব্যুনালের আবার দলে চলে যাবে
ট্রাইব্যুনালে কথা কি বলছে
আমাদেরই প্রথম হবে
That's yes,
page
page
53.
53.
Yes, my lord, my application.
Page 53 is the memorandum.
Yes, memorandum. Second paragraph, my lord. May I? After careful consideration of the matter, the government.
এগুলো একটু শার্পেন করে দিতে পারবে Yes, where you are placing?
Paragraph 2, my lord.
No, read from the top, huh? You can read it, Mr.
Yes, it has come to the notice.
Acha, after careful consideration.
After consideration of the matter, the government has now been pleased to order that these casual daily rates workers who are remaining attached in various establishments of the government department, directorate, and regional offices for not less than 10 years as on 1st April 2010 and have rendered service for at least 240 days each year will be allowed the following benefits. So benefit number 1, the casual daily rates workers may remain engaged till they are attaining the age of 60. And my lord, paragraph 4, my lord. During the period of engagement, the service of such employee may be terminated because of involvement of criminal case, misconduct, delinquent, and incapacitated, etc. Or if any employee intend to opt out of the engagement on his own. And if I fulfill the condition 10 years or 240 days in each year, then I am remain in till 60 years. The tribunal observed that I have completed this condition 10 years as well as 240 days each year. So I am entitled to restate till 60 years.
So when the termination order was
Termination order. Yes.
When you were discontinued from 2017.
2017, 31st July 2017, I am not allowed to join my service.
So this is
College
the
office.
23rd April circular. What is the 22nd December circular? Page 56.
56 means the modification.
Modification.
Yes.
What modification was brought in?
Same, can you see paragraph 1, the benefit details of serial number 1 to 4 aforesaid order will be available effective 1st January 2011 of those casual daily rates contract here include contractual.
Also on the point number.
And my lord, point number 6.
Point number 6.
Yes.
If he fulfills para 1.
Para 1.
So what is para 1?
Para 10 years or 24 days each year.
This you have fulfilled?
Yes. Tribunal observed that in this last
Acha, para 10, please read. Paratenses benefit will be a one-time benefit.
One time pay.
Yes, sir. Now show us where was the recent order. What is this 20th May 2013 enhancement?
It has.
Enhancement of
Enhance.
it. Did you get that enhancement?
My lord, enhancement not get that, but my lord, benefit has been given.
I see. Now,
My lord, kindly see.
so after your termination, you approach the tribunal.
Yes.
Tribunal relegated for consideration.
First consideration.
Where is that order?
Page 82.
Yes, page 82.
Where is that first?
My lord, first my lord 74.
No,
Kindly
first
see page,
circuit.
page 74. That is the tribunal order, first order. Page 74.
Just a moment, just a moment. Where is the December circular, Mr. Kundu?
56, my lord.
56.
December 30th April 2010.
Now you're showing us page 74.
74.
Yes.
This is
Show
the
us what 74 is.
74 tribunal directed to consider my representation. Directed the authority to consider my representative as per GO 2010.
Acha, come to this order. This order kindly middle portion at para 3. 23rd April 2010
10.
circular is at page 53, na?
Yes.
Page 53, what is para 3? After the period of engagement, such an employee ceases on his attaining 60, he will be paid 1 lakh. Acha. Also later. Did you challenge your termination in the first writ petition?
No, my lord, the termination order was not given us, my lord.
Have you said
Yes,
that
yes,
fact?
yes.
Acha, so there. So
Thereafter, my lord, 82, my lord, that is
let us understand.
Sorry.
Acha, now you show now in the order, recent order.
Reason order, page 82.
Yes,
The
what do you
director of
want?
Palmi Institution rejected my claim.
Which portion is important? Tell us.
My lord, kindly see, my lord, kindly see page 83.
Yes. Please.
The crux of the submission made on behalf of the petitioner before this tribunal was that the service of the petitioner was terminated without any written order. And so no order was given.
That is your submission.
And claiming any reason for that the violation of memorandum 2010, and she had not paid the salary since April 2017. Admitted no termination order was no termination order was issued, but the principal Evans College reply in communication by the district magistrate Kujbihar. In this context, the petitioner's complaint informed that the Deepali Horizon was appointment daily wages basis sweeper of ABN Seal College Kujbihar in terms of assistant secretary such and such government orders. On condition that after fulfillment of the post by the permanent staff, the daily wages appointment will be terminated as per government rules. It was also informed that one Lalon Baspor joined the college as permanent sweeper. But I am not claiming the permanent post. I am claiming 2 sweeper posts. There is
You are
lying
seeking
vacant.
the benefit of the 2010
Yes.
circular.
Yes.
And the subsequent circular.
Yes. Now it is to be ascertained from the material available in the file. Petitioner case is that she has paid her daily wages up to March 2017, and thereafter she submitted wages bill from April 2017, but those bills are not clear by the college, and for that had to move this honorable tribunal. Therefore, the emerges for the materials on record that the petitioner joined the college sweeper daily wages basis on 21st June 2004, and her engagement was
When did the Deepali when did Lalon join?
Lalo joined 2011.
Just. Give us the date now.
2011. Hello, 22nd July 2011.
And you were allegedly terminated in
2017.
2017.
Yes.
Yes. Place it next. As such, he did not work after 30th of March
Yes,
20.
as per the report of the principal. In this drawback and backdrop, it is to be decided as to the scope of the application of the geo number such as per direction of the Honorable Tribunal. The government of the West Bengal Finance Department issue memorandum in order to ensure security to tenure, appointment, anomalous, and certain retirement benefit of the casual daily workers who are attached of various establishment of the government department, directorate, regional office for not less than 10 years as on 1st April 2010 and have rendered service for at least 240 days each year. That is the condition of the said geo. And my lord,
The word and appearing in the geo. Where
And,
is that
yes.
portion? And
my lord.
page 53, where is that and?
Yes, and.
That is second paragraph.
Yes, my lord.
For not less than 10 years as on 1st of April 2020.
And have rendered service for at least
Very good.
240
Now
days
what
each
did
year.
the word and appear has to be construed conjunctively and not this. Very good. It means in order to avail we'll have to render minimum 10 years of service. So 94 10 years you did not complete. You were engaged in 94.
Yes.
So 10 years
Initially.
initially.
Yes.
So what is it means that casual in order to avail benefit we'll have to render.
Pending করে দিয়েছি, this is less than this. It's not entirely fact. It's more clear that if it says that already there are this hopefully any benefit of labor particular, it has not fulfilled. If you got a reason of it, but has some date on that important fact, that will dispute for it. That is which is circulated as a provision that say okay, not less than 10 years total. Issuance of the Salvador period, he does not fulfill that clause. From 94 94 থেকে 94 থেকে যদি 2010 হয়, গত বছর 16 বছর হয়ে যাচ্ছে। আর 94 থেকে 2000 16 বছর হয়ে যাচ্ছে তো। না 2004 দেওয়ার করছে দেখবি। 2004 দেওয়ার করবে, মানে 6 বছর হবে। এবং প্রতিবার সে 240 দিন ধরে কাজ করেছে, সেটাই এবং 6 বছর হচ্ছে এটা। পুরোটা 2010 ছিল, 6 বছর হয়ে গেছে। 2010 পর হয়েছিল।
When was your initial engagement? Page 41. Your initial engagement.
38.
38?
38 means that is the just order, my lord.
Page 38.
Page 38.
No, what is page 41?
In terms of the page number 41, he was appointed in the
41?
year of 2024, man.
41.
Formally appointed in the year of 2024.
Yes, we'll come back to you.
2003 সালে তো 9 years সার্ভিস হয়ে গেছে। তাই বলেছি 2003 সালে
Kindly see first page 38, my lord.
38?
Yes.
Acha. What you want to show 38?
38, well, I was engaged, my lord, but I have not upon paragraph 7, Dipali horizon, my lord.
Page 38.
38. That is the issue, my lord. 3rd August 99. Second, my lord, is Dipali horizon part-time sweeper.
Second, where you are showing? Yes, the part-time super.
These are
Yes.
the duty roster, my lord.
This way is superseding the previous orders, the under delays of whole-time sweeper and patrol.
And part-time sweeper. Of the college for following.
Acha, very good, but Mr. Kondu, where is your appointment? This is issued by the officer in charge admitting that you are joined in 1999.
And page 42, that is the certificate.
As a part-time sweeper for 9 years. This certificate is being issued when? 2003.
3.
Acha.
9 years from that time.
So your contention is that prior to 1/4/2010, you have completed 10 years. But in this letter at page 38, this is superseding the previous orders, the undersigned directs whole time such and such. This will be the roster. So in 99, you were in service. So if 99 you are in service, it becomes 2010.
Circular issue published. So
9 years. How 10 years?
99, my lord, 10 years, my lord.
99 to 2010. Oh, then 10 years.
11 years.
11 years.
11 years. Very good.
2003 তে 9 years হচ্ছে কি করে? 2003 তে বলছে যে completed 9 years. না, page 42.
ডকুমেন্ট টোটাল ডকুমেন্টটা দিচ্ছে যে 99 ও কাজ করছে পেজ 38
99 থেকে
সেটা যদি ধরে নিই, এটা যদি নাও,
এটা তাহলে 94 থেকে ধরা হয়েছে।
এটা নাই ধরি না, এটা না ধরলেও 99 থেকে এটা তো গভর্নমেন্টের মেমো।
প্রিন্সিপাল থেকে ধারা ছিল।
উই টু প্লিজ
তাহলে তো 9-10 বছর হয়ে যাচ্ছে।
10 বছর।
ফ্যাক্টস রাইট অ্যারাইভ কমিটি দিচ্ছি।
Very good. You were reading page 84. So yes, it was said that and is conjunctive. It is true that petitioner rendered 240 service in a year, but her length of is in total counted from why they are taking this 1st June 2004.
21st June.
Because,
Why
my lord,
21st June?
21st, my lord, another appointment letter was issued in favor of
This horizon.
yes.
Where is that letter?
page 42.
Page 43, my lord.
Oh, 42, 43.
তখন সমস্ত লেটার গুলোকে ধরে পৌঁছচ্ছে কিনা সেটা দেখতে হবে। The object of
Yes, 43. This is 2024. Place. It is notified. Place the letter.
It is notified that the WA BSc part 1 and part 2 honorable and no, my lord, that is the schedule of Dipali horizon.
Then
Page-
why you are saying? Which page
Page
you are?
44.
Yes, place.
44, 45.
আবার বলে 44.
As per the order of Honorable High Court, Calcutta, he was requested to appear before the interview.
Where is this order of High Court?
High Court order is not any.
Acha, then dated, what is the date of the High Court order? 20 something May 2004.
23.
Requested to appear for before an interview. Acha, this is 2004. Now page 45.
এই 1806 আমার অ্যাপয়েন্টমেন্ট লেটার দিয়ে দিই।
এটাই গন্ডগোল করতে হয়।
দেখতে হচ্ছে ওটা মানিটা কি বিষয়।
So when was your initial appointment is 94 you are saying? From which document?
মানে His document well certificate issued by the college authority. Page 42.
Then how do you explain this page 44? 44 says that you appeared in an interview. Now you were appointed. So how do
Irrespective
you-
of you were working, you appeared in the interview.
Yes.
So what is the distinction between that up to 2003 and after 2004? Any distinction? Or same service?
Same service. Same service. Sweeper part. Same service.
show us one document as per your parent appointment?
There is no initially appointment letter. As per document, page 38, in
Then
99.
Mr. Kundu, how do you overcome this memo? Page 45. 45 says there was a selection, you participated, you were appointed.
But my past service, I am.
Yeah, just a moment. Now come to page 53. What does the circular say? It has come to the notice of the government that for some time past for implementation of various schemes, contractors have been compelled to engage casual delivery in many cases. These employees remain for substantial even for more than 10 years. Their ground of rejection is you did not complete 10 years on the date of 1st of April 2010. This is their contention. Your recent order said that it has to be 10 years and it has to be 240 days continuous. 240-day continuous, satisfied, but for the period of 7 years.
Tribunal observe, kindly see tribunal.
Yes, take us to that. Now finish this off. It is true. The ultimate dismissal was what? Fell short of 10 years. This is their condition that it has fallen short of 10 years. Now, please read that line. It is true that the petitioner, page 84, but a length of service in total counted from 1st of June 24. What is this date? 1st August 2011?
Page 55 টা দেখুন আরেকটা ট্রাইব্যুনালের অর্ডার এই একটা মামলা করেছিল 55 আবার একটা অর্ডার নিয়েছে 55 পেজ
সেটা তো কনসিডারেশন।
তাহলে 6 বছর কাজ করার পর সব চলে যাচ্ছে। এই 6 বছর কাজ করলো 55 এটা তো ওই সার্কুলারের পরে মামলা করেছে 55 আগে সরকার কিন্তু নিয়েছেন
মিসিং।
না এটাই অ্যানেক্সে পি এর আগের পাতা আগের ঠিক আগের এখন এই পাতাটা নেই এই দুটো পাতা নেই দেখুন এই অর্ডারটা সূর্য অর্ডারটা এগুলো মামলা করে 2010 মানে ওটা অনেক পরে মামলাটা করেছে কিন্তু 10
Yes, 2010, one order was annexed.
That is not in my file.
yes file a copy সার্কুলারটার পরে মামলাটা করেছে
এই সেকেন্ড পুষ্টি গল্পই নেই। এইটা পরে তো ওর গল্পটা কি আমি রেগুলারাইজেশন বলছি বেনিফিটটা চাইবে এবং 60 বছর দিলে আমি চলে যাবো আমার 1,000 টাকা
সার্কুলারের পরে তো এটা আবার ফেল করেছিল
কনসিডারেশনে পাঠিয়েছেন ওইটাই
আবার নতুন করে যদি হয় স্যাংশন পোস্ট ইউ শুড বি কনসিডার্ড
there is available sanction কিছু বলেন begins to appeal করলো না।
তার মানে এই জিনিসটা জানালো কি ও অনেকদিন থেকে কাজ করছে তো অবজার্ভ করছি 2017 অনেকদিন থেকে কাজ করছে তাহলে ওকে 2004 থেকে ধরলো কেন যেহেতু ওটা একটা ফ্রেশ অ্যাপয়েন্টমেন্ট লেটার দিয়েছে ওদের মতে ওদের ক্যালকুলেশন অনুযায়ী 2004 কি করে ধরে আসছে।
Yes. Now, please read that remaining portion, page 84. It is true that petitioner rendered 240 days counted from 21/6/2004, fell short of 10 years as on 1st release. Or as on 1st August 2011, as per circular dated 6 September to which was issued in supersession of circular. That being so, the benefit of author or the GA cannot be extended. So very good. Now constant to appear. So you were defeated on the ground that your engagement was less than 10 years as on 1st of April 2010. Now what did the tribunal say? Internal page 2, second paragraph. Please read from second paragraph.
The dispute regarding the date of her joining has been made clear from the memo, copy of the memo dated 18th June 2004.
That is page 43.
Yes, 43, 44.
Yeah, just a moment.
এইখান থেকে ধরে নিয়ে যে এই জায়গা থেকে এটার উপর ধরেই চলছে।
45, page 40.
Page 45, yes.
Annexed with this application by the applicant herself.
Hmm.
By an order dated 18 June 2004, Dr. D.K. Naha, the principal of college, issued an appointment letter to the applicant. Deepali eroded in the post of sweeper purely on temporary daily rates and no work, no pay basis. Attention is also drawn to the certificate issued by the same principal dated 16/9/2003. That is page 42.
So if we 42, in 42 it is you were engaged in say 42 certificate says you are working from 9 years.
Right.
So it takes us to 2003, 9 years prior there to means 94. Very good. Then what happened? Then
By which it was certified that the applicant has been servicing as a part-time sweeper since last 9 years. From this certificate, it is also clear that the applicant has been servicing in the post of sweeper since 1994. However, only by an order dated 18/6/2004, the principal issued her a formal appointment letter for the post of sweeper on temporary basis. The question now before this tribunal is whether to accept the formal appointment letter counting his service from 18/6/2004 or when she was formally engaged since 1994. It is not a dispute that the applicant was engaged by a formal engagement order, but the certificate issued by the same principal on 16/9/2003. It is clear indication to the fact that the applicant has been working even without a formal order in the post of sweeper since 1994. From the above observation, the tribunal has come to this conclusion that Deepali Horijan, though engaged by a regular order since 18/6/2004, it is particular 2004, has been working in the same post since 1994, as evidence from the certificate of this to this effect stated clearly by the principal of the college. Thus, from the record, it is evident that she has worked since 1994 till her termination on 31st July 2017, having served for 23 years.
Then where is that portion of rejection of reinstatement? Tribunal has commented nothing about your
Yes,
reinstatement.
the last paragraph.
Yes. Response to accept
Hence,
the
it
fact,
applies
just a moment. Certified by the government cannot ignore the agenda. Hence, tribunal directs to grant a remuneration 94 along with baggages now. Does not interfere with prayer B.
For reinstatement of her daily rest worker as a sweeper, the tribunal has satisfied that after due process of selection for the post of part-time sweeper has been fill up by another person. No, part-time sweeper has been not fill up. It is full-time sweeper has been fill up by Lalon Horijo. It is 2011.
Show us that page.
If 2000, my service only one time. If 2011 is Lalon Horijan is admitted, then and there I was terminated. Why the college authority take my service 2011 to 2017? After 2017, my submission is that after 2017, some chargeable person come to the college. I was thrown from the college.
No, he came on which year? Your
Lalon Horijan 2011.
2011. At
Join-
that time, you were not terminated.
No, that time not terminated.
Hmm.
I was
So
continuing.
your argument is that this plea that a new incumbent has joined, so you are being thrown away.
Yes.
This is not sustainable
Well, not
because you
just the practice is-
continued from 2011 till 2017.
17, I was
So there was no ground. This engagement of that person in a permanent post cannot be a ground for your termination. This is
Yes.
your argument.
yes. I am engaged daily rest, but part time. And Lalon Horijan is post is full time, permanent.
What is your age now?
53. But I am servicing 23 years. I am servicing the college authority. As a sweeper.
Now you have been discontinued. You have not been allowed from
No,
2000.
not allowed. From 2017.
Acha, show us your prayer in the tribunal application.
Page is 33.
No, you are saying that this ground taken by the tribunal that after due process of selection the post of part-time suitor have been filled up by another person. This contention is wrong. That is your argument. Because had it been so, then you would have been terminated in 2011 itself.
11. Then and there.
Have you annexed your original application?
Yes, my lord, it is continue page 21 onwards. And my prayer question is 33.
You are Deepali.
Deepali Horijan.
Achha, before that, come to page 51. What is page 51? If your name is from internal exchange.
Which one, my lord?
না অথরিটি তেমন লালন ঢুকলো তো 2011 এই চিঠিটা আপনি দেখুন 2007 51 পেজ
51, my lord.
Your name was called from exchange.
Yes, my lord.
Your name was
Yes, because my lord, 51, my lord, that is the interview letter on behalf of the petitioner for the said post.
Permanent?
For the said post, that is Lalon Horijan is engaged.
That is permanent.
Permanent.
So then you have participated in that selection.
Yes, I have participated because I was already working in the college.
So after the permanent selection also, you continued
Yes,
temporary.
yes, yes. Temporary.
সিলেকশন হয় না সয়কি লালন না সেটা তো বলছে 11তে ঢুকলো লালন ও তারপরে চালিয়ে যাচ্ছে পার্মানেন্ট আছে টেম্পোরারি আছে দুটোই চালিয়ে যায় দুটোই চালিয়ে যায়
Temporary post is now vacant.
Hmm?
Two post is live vacant college.
Temporary.
Temporary post. Daily wages. That is.
Two temporary posts are lying vacant.
Daily wages. And my lord, as per the order of this coordinate bench of this honorable court.
You have kept one post vacant. Very good. Anything else you want to submit?
My lord, kindly see page 33. My pair question of the tribunal.
Yes.
Page 33.
Prayer B.
Pair B. I am not claiming regularities. I am claiming my same post.
Page 30.
33, pair B.
Reinstate.
The state was same course. The applicant had daily rates for and back wages. I am not claiming in regularize or part.
Acha, where have you made amendment as regards your termination? Which paragraph?
Page. Page 10, paragraph 22.
Page 10.
Yeah.
Page 10 of the tribunal application.
No, my application. Tribunal application.
It's 30. It's 30.
Have said mandatory presentation.
2021 টার্মিনেশনের কথাটা কোথায় গেল?
Yes, termination in which page? 30.
পেজ 10 এও কোথায় টার্মিনেশন কথা?
It is representation.
কিন্তু রেগুলারাইজেশন প্রসেস।
No, so it's going to happen another person to a permanent post. For that representation is made.
Page 30.
30. Where is that? Where have you said that you were terminated? Your
Because,
prayer is for reinstatement. But when
Page 30, second paragraph.
yes, place.
That you replace that she moved an application before the tribunal since she was terminated orally from the college authority, despite several government orders that the casual delivery was.
So did they file reply to this? In the tribunal they used.
No reply was submitted before this time.
So your argument is that in terms of 2004 circular,
Yes.
2010 circular, you have worked for more than 10 years in view of the circulars, and that fact has been admitted by the tribunal. Against that, they have not preferred it. They have accepted the order and they have paid you wages till the as directed by the tribunal till 2017.
2007.
Tribunal directed that you pay till 2017 to grant her remuneration since 94.
It's 94.
As above, along with back wages and everything. So the point of prayer B is at which page you said? Prayer B?
Page
33.
Yes.
What is it? So where is the story about your termination? Where have you said that you were appointed in the tribunal ordered Mr. Roy? Means you said when Mr. Roy appeared for the state, tribunals contended that he was terminated. So when you were terminated in 2017, first you came up with a tribunal application, page 55. That 55 is not with me. I think. কি বললো? অর্ডারটা কবে হচ্ছে দেখুন তো? না এও তো হবে না, টার্মিনেশন তো 2017।
সার্কুলারের পরেই এটা দিয়ে এসছে। সার্কুলার তো এপ্রিল মাসে কিন্তু নভেম্বর মাসে মামলা সেটা আমি কি বলবো?
Sanction contemplation of feeling should be given up.
ওকে যদি ফ্রি অফ পাস করবে
এটা কিছু হলো না।
না না এর কিছু হলো না।
ও তো
Yes,
পার্মানেন্ট
madam. Just
রেগুলারাইজেশন চাইছে।
এটা এই তো বলতে গেলে সেটা হলো পুরোনো গল্প। এটা ট্রাইব্যুনাল যেটা হচ্ছে পরবর্তীকালের গল্প, যখন ওকে আর কাজ করতে দিল 2017 পর থেকে দিল না, এটা 7 বছর আগের ঘটনা।
গভর্নমেন্ট করলো না যে আমার থেকে
জনগণের ট্রাইব্যুনালের কাছে করেছে, ট্রাইব্যুনালই তো অর্ডারের মধ্যে মেনশন আছে আর কি।
না না, এই যে রিইনস্টেটমেন্ট ইস্যুটা,
রিইনস্টেটমেন্টটা বলবো করার জন্য স্পেসিফিক গভর্নমেন্ট
2017 এ যে টার্মিনেশনটা ওয়াজ ব্যাড, ওরাল টার্মিনেশন, সেটাও কোথাও বলেনি।
সেটা কিন্তু নট অ্যালাউড টু ওয়ার্ক ফ্রম 2017 ট্রাইব্যুনাল অ্যাপ্লিকেশন
কোথায় ট্রাইব্যুনাল অ্যাপ্লিকেশন?
The tribunal application, have you stated that from that date you are not allowed to work? Which paragraph? Page?
কিন্তু রিপ্রেজেন্টেশন
ওরা নিজেরাই অ্যাডমিট করে নিতে, স্টেটই অ্যাডমিট করে
94 থেকে
97 2017 তে টার্মিনেট করেছে।
করেছে ওদের যেটি হলো সেটা ফাইন্ডিংস হয়ে গেল ট্রাইব্যুনালের।
তাহলে তো মেয়েদের টার্মিনেশন ওয়াজ গুড অফ দ্য সেটা
ওটাকে ভায়োলেট করছে কিনা, এই যখন পিরিয়ডটা মেনে নিচ্ছে তখন ওই পিরিয়ডটা যেহেতু আটকে যাবে মেমোরান্ডামে।
কি করে আটকাবে? 10 বছর যে ফুলফিল করতে লাগে
94 থেকে ধরতে হবে।
ধরেছে তো, ট্রাইব্যুনাল 94 থেকে ওকে 10 বছরে
অথরিটি বলতে 2004 এখানে অথরিটি
এই ওদের স্টেট
ওটা দিয়ে
ওটা অ্যাকসেপ্ট করে নিয়েছে যে 2004 10 বছর কাজ করেছে।
একদম
এবার 2004 পরেও যখন ও কন্টিনিউ করেছে ফর অ্যাবাউট 11 ইয়ার্স 13 ইয়ার্স কাজ করার পরে 2017 টার্মিনেট করে বাড়ি যাবে।
তখন 2004 পর থেকে তো করছে 17 তো
এক্সেপ্ট
সবই 2010 ওটা ফুলফিল হয়ে গেল।
2017 তোকে বেনিফিটটা দিয়ে দিল।
ওটা তো কমপ্লিট করে নিচ্ছে আর কি।
So now they have given you benefit treating you to be in service till 2017,
till 17 March 2017.
March 2007. Now your contention is you reinstate me. Why? How do you, what is your argument? Why should we allow that prayer?
Yes, should be allowed, my lord.
You have been paid the entire, your only ground is now 2017, from 17 till date you have not worked. You have not worked. So your retirement will be
Okay.
after after 4 years, after 4 years.
7 years, 6-7 years.
So if you are, suppose you have not worked till 2026, 2017 to 26, you have not got any money. You're right. So this tribunal order came on 13th of December 2024.
20.
Yes, sir. What is your contention?
My lord, I need to add 2 points. Kindly
Yes.
see the affidavit of opposition. Affidavit of their affidavit of
Yes.
affidavit of opposition, page 3.
Page 3.
From 31/7
Yes.
terminated.
Paragraph 2, Melo. The Deepali Horizon was engaged as sweeper daily race at Acharya Vijayendra Nath Seal College. When she was appointed, they did not mention any date. So it is admitted position. I was.
Who is respondent number 3? Affidavit affirmed by respondent number 3 is the DPI.
My lord.
Huh?
Well, Director of Public.
Huh?
Yes, my lord, the Director of Public Instruction.
Wait. Yes. You are showing us page 3, huh?
Paragraph 2. There is no date when I was engaged. So it is admitted position. I was engaged 1994. She was terminated with effect on 31st July 2017.
Ground for termination.
This cannot be a ground for termination because after 2011, ওকে যদি 2011-তে বসিয়ে দিত তাহলে পার্মানেন্ট পোস্টে লোক ঢুকে গেছে, তোমাকে আর চান্স তারপরে তোকে দিয়ে কাজ করিয়েছে। দ্যাট ইজ আর ইন্টারেস্ট প্র্যাকটিক্যাল কাজ করানো করে আমার তো কিরকম কাজ কাটতে পারবে এই জন্য ওকে জয়েন করাবেন 2017 আমরা তো কোনো বেনিফিট কারেন্ট বেনিফিট পরের যাতে ইউজকেট করছিল তো একটু কাজ করতে তো ব্যাক রেজিস্টারকে আমরা পুষে দেবো যেহেতু ওয়ার্ক করেনি কারেন্ট পরবর্তীকাল থেকে বছরের কাছে করে দিই।
Anything else, Mr. Kundu?
Paragraph, point number 3, 3, she was terminated with effect 31st July 2017. No termination order was issued to me. No opportunity of given hearing. That is violation of principle of natural justice. So far, my short knowledge. After 2017, I was not allowed to join the college. Only one. This is the Lalon Horizon was appointed part-time sweeper. Part-time sweeper. I am not claiming the part-time sweeper. I am claiming the daily base.
No,
permanent sweeper. Permanent sweeper.
Permanent.
Permanent sweeper. I am claiming my daily base post.
And there are vacancies.
Yes. And Lalon Baspur, my recently instruction, Lalon Baspur already died. This post was also vacant.
So what is your prayer before us?
Only my prayer is to restrict my service. To restrict my service as my I was.
You are
Daily
presently, what is your age?
53. If I join, then I continue more than 7 years, more than 7 years, till 60. I am a sweeper. I am a lady. I am service 23 years. Sympathetic ground, lordship.
Yes, sir.
My lord, the petitioner has been appointed in the year of 1994 on superannuation of 2 sweepers on the daily rated basis. My lord, they have been daily rated work in the said college, and my lord raised her bill, and as per his bill, my lord, his bill has been cleared. Subsequently, in the year of 2023, as per the notification of the Director of Public Instruction, that he may be appointed in the post as a part-time sweeper until my lord one permanent post has been filled up.
Where is that?
Page 41. I am direct to refer you that so and so or above.
Page 41.
Page 41. On a daily basis against the vacancies.
Just. Page 41.
Madam.
Yes, page 41.
I am directing to refer you that the letter number so and so on the above subject and say that 2 sweepers may be engaged on daily basis against the vacancies likely to occur due to the superannuation of Sri Tamala Harijan and Srimati Tara Harijan on 1/8/2003 and 1/0/2003 respectively on the fulfillment of the existing rules till the appointments are made regular basis until the further orders. And by this notification in the year of 2024, my lord, he has been appointed. And my lord,
2024?
Sorry, 2004. My 2005, she has been appointed.
Page
45, my lord. Appointment of the post of the sweeper on daily rated basis.
But sir, how can you take that point? Tribunal has decided and have directed you to treat his service till 2017. And you have accepted that.
Yes, my lord, but from the 2004, not from the 1994.
Then why you are accepting the order? Tribunal has said that you have to treat him to have been appointed in 1994. If you treat him to have been appointed in 2004, then he does not cover the period of 10 years prior to issuance of the government memo.
My lord, we have.
You have accepted.
My
You have
lord,
accepted that engagement is 94
No, my
or
lord,
rather 93.
we have only accepted the, my lord, the terminal.
Then you did not challenge this order.
We have
Then
challenged.
how can you now, you have given him the benefit. What did the tribunal say? That give him the benefit since 1994 and you have paid that amount. And 1994 till what is the date of issuance of the circular? That is
April
1st of April 2010.
10.
My lord.
So 94 till to 2010, 10 years is crossed in 2000.
That is 16 years, my lord. But my lord, our contention is that, my lord, she was formally engaged in the year of 2024.
That ground you
2000
cannot take now.
And my lord, as
That
per the
ground, sir, you
notification,
can-
my lord, only 6 years, sir.
So you should have
My-
challenged this order.
That is tribunal's order is
They did not
94.
challenge and they have been paid.
They have not channeled, you have paid from 94. Now, sir, tell us how could you sustain your order of termination? There was no order of termination also. One day he came, you threw her out. Go back home, we will not allow you. You are the state, the model employer. You have extracted for 23 years from a woman.
No, my lord, he is a daily rated wager, my lord, he have been paid.
Then you must have said something. What is your argument before us? Your argument is kindly see page 41. How did we appoint him? We appointed him since there 2 persons retired and he was inducted to superannuation and respective of fulfillment of matter of filling regular against vacancies due to superannuation of Tomola and
Tomala
Tara.
Pujan, Tara.
Now you are showing page 45. What is
You see,
page
prior
40?
to this one also, she is working, prior to this 41 circulars.
She is selected for sweeper for college, no work, no pay, service will be as per necessity.
But my lord, their only weapon is the, my lord, the certificate issued by the principal.
No, you
They are
are,
only weapon.
you are
My-
Mr.
Go ahead, my lord.
Mr. Gorai, kindly, we accept you.
Right.
You have, your contention we would have accepted.
If we file an F. But my lord, another case is, the point is that, my lord, the tribunal has not gotten into their prayer, my lord. They have simply did not enter into their prayer.
We will enter, sir. We are in judicial review.
My lord, then, my lord, let revert back to the, my lord.
না আবার কি remand back?
Otherwise, my lord,
You
they have not
satisfy,
decided.
huh?
My lord, the tribunal.
Why
is
the matter
decided.
will be delayed in this way? It is
Tribunal
already
has,
delayed.
what the tribunal said, tribunal is satisfied that after due process of selection, the post of part-time teacher has been filled up by another person. This observation is contradictory to tribunal's first observation that you treat him to be in service from 1994. This is self-contradictory.
Right.
Isn't it, Mr. Gorai?
Right.
Your argument is page 41, place page. Where did you say that till appointment of regular employee? Where did you show?
My lord, it is in our recent order, my lord. If your lordship kindly come. 84 page number.
84.
Sorry, put it.
Where is that, Mr.?
One. On page 83, first paragraph, my lord. Page 83, sorry, my lord.
82.
83, my lord. On behalf of the petitioner, a written notice of submission was filed and several documents were annexed thereto. It appears that the college later under memo number so and so, annexure F, Srimati Deepali Harijan were appointed on the as a sweeper on the college on a purely on a temporary daily rated and no work, no pay basis. And a service would be required as per the necessity of the institution and payment would be made as per the government rules. it further appears from the petitioner's own admission in Annexure 8 that she has been joined the college as a temporary sweeper on 21st of June 2024, pursuant to the appointment letter on 2004, my lord. It is their appointment, their admission, my lord.
No, where is that she will be continued till a permanent incumbent comes? Where is that observation?
My lord, second paragraph, page 83, line number 11. My lord, the Assistant Secretary, Government of West Bengal, GO, 31st of June 2023, on the condition that after filing of the post by the permanent staff, the daily wages appointment will be terminated as per government rule.
Where is that? Page 41. This is 31st July. That line is not there in the memo of 31st July. 31st July memo says that you are appointed since there had been a superannuation and you are on fulfillment of the existing appointment. The matter, where is that line? You will continue till the post is filled up on permanent basis.
Line is there,
That line is not there.
but it is reported in the recent order.
Yes, what else you want to submit, sir?
And my lord, on the last coordinate bench, it has been also my lord pointed out that she have been working in another place also.
Eh?
Yes, my lord. If your lordship kindly comes to the page 87, that is our, my lord, bank details. My lord, there is another entries of money.
Show
month-
your document, I have engaged or not.
Page 87?
Page 87, my lord.
Yes. What is this?
That is bank statement.
That is a bank statement.
Who enclosed it?
My lord, the petition.
Well, I haven't.
So what he will do? You will throw her out after 23 years, she will die.
No, my lord, she will.
She has to take
working
engagement.
in another place also. And my lord, she have been appointed only on the ground that a
So
daily
very
wages
good.
letter. She have
Pay
been,
him
my lord-
pay him 5 lakhs. We are not saying anything.
My lord, we have already
Finish.
paid 4
Did
lakh
not
70,000.
mention anything in this.
That is up to
petition.
2017, sir.
Yes, my lord, as far as calculation.
After retirement, she will get 1 lakh. As per the circular of 2000. You cannot, this 1 lakh period is on. We can say that for the period from 2017 till today, she has not worked. As you have shown that she was working somewhere else. So very good, we will
No,
say
my lord,
that.
she has not, after 2017, she was somewhere else. From the beginning, my lord, he was working somewhere else also.
So that is not a ground in your
That is new
earlier
ground.
process. This, if you say this, you reinstate him from today, and you pay him the benefits of regular scale from the date of reinstatement.
No, my lord, he is already there is already a permanent post have been filled up by the permanent staff, my lord.
Thereafter, he rendered service.
That was in 2011. Permanent staff was filled up. Now there is permanent staff filled up or not, we do not know. When you can, 2011, you appointed the permanent staff, then what is your explanation for continuing him for 6 more years? There was no necessity. But you are the state, you cannot act arbitrarily. So today, one fine morning, you tell him to come here, throw you out of the college. Is that proper? So if it is that not proper, we give you 2 options. First option is that reinstatement will not be required. You pay him the amount which, how much is your pay? How much did you get last time?
Last time, salary is 5,000. 5,642 per month.
Very good. Say suppose 5,000. So today we are in 26. She will retire after 4 years. You make a lump sum payment finished, we will not interfere with this order.
Or I have to take instruction in that.
What is, government will say, I will pay.
Then my lord, without instruction, I cannot stay.
Then we pass our orders, sir, what can be done?
But my submission can be recorded.
Yes, yes, go to Supreme Court, sir. No, do you, is there any, your advising council has said you anything, advising officers about this proposal? Because now, Mr. Kundu, what is your age now? You are saying 56. Where from you will come?
53. मतलब I annex the Aadhaar card and affidavit.
সম্পদ অলরেডি একটা স্টে করে রেখে দিয়েছে বুঝতে পারছি না এবার আরেকজন থেকে মারা গেছে একটু বছর 17 স্যালারি ওটাকে আমাকে ইয়ে করতে হবে আর কি 17 থেকে মনে করেছি একটা ওয়ার্ক করতে আইডিয়া মনে ব্যাক হয়ে গেছে না ওইটাতে ব্যাক হয়ে গেছে ট্রাইব্যুনালের অর্ডার এটা আপনি 2017 ওই অবধি পেমেন্ট করতে বলে দিয়েছে গ্রান্ট রেমুনারেশন
So you have granted remuneration till which date? From 1994 till which date have you paid him remuneration?
July 2017.
Till July to the, you have stated
My
anywhere?
lord, page 4 of my AO, my opposition. Page 4, paragraph 5. That after receiving the above order, the concerned college was requested to submit the detailed calculation sheet for the claim of wage from 1994 to 2017. And the college authority submitted the claim from 1994 to 2070 amounting to 4,72,101, and the amount was been sanctioned by the director of and paid the Dipali Horijan by the college authority.
টাকা না নিয়ে হবে আমি কতদিন থেকে না ওটা তো 17 থেকে 24 অব্দি বসিয়ে গেছে 2017 অব্দি টোটাল করে দিল 2017 অব্দি এবং তারপর 2017 তারপর থেকে তো পাচ্ছি ওইটাকে চ্যালেঞ্জ করে ফেলবে টাকা এটাও একটা ব্যাপার 17 থেকে 24 দিতে পারে 26 দিতে পারে আমরা ম্যাক্সিমাম বলতে পারি remuneration till she attains the age of superannuation. And pursuant to such she shall also be entitled to the payment of 100 rupees in terms of which is ruled as a government circular. এটা আমাকে যত জাস্টিফাই করবে বিকজ উই আর নট ওয়াট এটা তো ডিসমিসাল ফ্রম রেগুলার পার্মানেন্টলি না ডিসিপ্লিনারি প্রসিডিংস ডিসিপ্লিনারি প্রসিডিংস টার্মিনেশন হলেও 50% ওয়েজেস অ্যালোকেশন হয় ওখানে কিন্তু এখানে আপনি দিতেও পারেন শর্টেরও থেকেও দিতে পারেন 50% ওইগুলো কি মানে ব্যাপারটা ব্যালেন্স হয়ে যাবে একই চলে যাবে 50% দিলে সুপ্রিম কোর্ট চলে যাবে টাকাটা স্টে করে রেখে দেবে ওইটুকু করে বেরিয়ে যাবে আমরা ওইটা যদিও 17 থেকেই মেন্টালিটি কিন্তু পৃথিবীর ফ্র্যাকচার্স আমরা এটা ব্যাক করে যান সেটাই কিন্তু আপন যাকে দূরে রিইনস্টেট করে ওর ফিটনেস হয়ে যায় superannuation এর বয়স তো আর ভাই। তিপ্পান্ন বছর বয়সে কাজ করতে পারবে। তো এর জন্য তো আবার নতুন করে মেডিকেল সার্টিফিকেট দরকার হবে। ওই যদি প্রয়োজন মনে করে ওরাই করে নেবে।
Mr. Kundu, why did you challenge the tribunal's order? Where have you said we have challenged the order partly? কোথায় করেছো? You have challenged the entire order. It's a problem.
Technical trouble.
Should be careful, Mr. Kundu. You have challenged the order which has given you benefit. You should have challenged that only portion of the order which is against you.
You have received the benefit also. What benefit he has received? And the order is not severe enough.
Severe able into second to severe করেই চ্যালেঞ্জ করেই The present writ petition has been preferred. Primarily challenging the observations of the learned tribunal made in the penultimate paragraph of the order dated 18th November 2024. Order dated 13 December 2024. Passed in the original application being OA 194 of 2024. Wherein the tribunal observed as follows. বলে এই মার্কটার পোর্শনটা দিয়ে দিই। পেজ না সার্টিফাইড কপি পর। Stop. The present case has a checkered history. Stop. The petitioner, namely Dipali Horijan, bracket A, he short Dipali. As a sweeper in the ABN Shield College, bracket General State College, on purely temporary on purely temporary basis and on no work no pay basis. No work no pay basis. Stop. Having thus completed more than 10 years of service. Your initial date of appointment you have stated anywhere? তাহলে ওই যে দিস কেস হ্যাজ আ চেকার্ড হিস্ট্রি না, ওটা কেটে দাও, কেটে এরম ভাবে লিখো। Mr. Pundu, learned advocate appearing for the petitioner, namely ওই দীপালি নাকি, submits that Deepali was initially, that Deepali was appointed as a sweeper in the ABN such and such college on purely temporary basis, and on quote unquote a no work, no pay basis. Way back in the year 1990. Huh?
Yes.
What yes? Where have you stated?
Paragraph 3, page 3, 1994. In the year 1990. Paragraph 3, page 3.
Of your
My application. First.
Paragraph 3.
3. Page 3. Done by the second date.
93 থেকে 10 বছর হচ্ছে, তোমাকে তিনিই তো বলছে যে লাইনেস কাট করতে প্রিন্সিপালের সার্টিফিকেট। পেজ 53 বুঝলাম।
ও বলে রেখেছে এখানে। Where is your letter? Where is your date? Paragraph 3, sometime in the year 94. Then how do you complete 10 years? On 1st of April 94, 2010? In the year 1994. Having thus rendered service for more than 10 years uninterruptedly, Deepali became entitled to the benefits on the basis of the government memorandum dated 23rd April 2000. Stop. Which inter alia provided that casual stroke daily rated workers may remain engaged till they are attaining the age of 60 years. Where is that 1 lakh direction? After retirement 1 lakh, where is that?
There is subsequent memorandum. Page 53. Page 0.3, page.
The said government order was followed by the said memo was followed by another memo issued by the competent authority on 26 in December 2010. Reiterating the earlier conditions with a further condition to the effect that where page 56, which point? 1 lakh?
1 lakh is under page 50.
Page 50, where?
Point 3.
Oh, আচ্ছা আচ্ছা। Followed with a condition, age of 60 years বলেছে তো? ওই যে বললে তারপর and that no, ওটা কেটে দাও, followed by that engaged till they are attaining the age of 60 years, and that they would become entitled to an amount of rupees 1 lakh as one-time cessation or as one-time cessation of engagement benefit. Stop. in support of such engagement in service, Mr. Kundu has drawn the attention of this court to the certificate issued by the principal of the said college, annexed at page annexed at page 42 of the petition. Mr. Kundu further submits that without issuance of any prior notice and without grant of any opportunity of hearing, Deepali was abruptly discontinued and terminated with effect from 31st July 2017. Such termination is thus ex facie arbitrary and malified. Stop. Advancing such arguments before this, Mr. Kundu submits that challenging such termination and denial of the benefits contained in the government memo dated 23rd April 2010 and 22nd December 2010, Deepali preferred an original Deepali approached the learned tribunal or the High Court. Approached the learned tribunal, and upon learned tribunal and by an order dated 9th December 2022 in OA 202 of 2021 bracket page 74 the issue was relegated for consideration to the competent authority. Pursuant to such direction, the respondent number 3, pursuant to such respondent number 3 passed an order on 20th February 2024 observing inter alia that the benefit of the memo dated 23rd April 2010 and 16th September 2011, 22nd December 2010, where is that 16th April? এখানে অর্ডারে দেখুন লিখেছে 23/16/2010
সেটা প্রথমটা।
The benefit of the memo dated 23rd April 2010 cannot be extended to Deepali, and that she is not entitled to the benefit of continuity of service up to 60 years of age. It was further observed that Deepali's prayer for regularization in service after termination on and from 1st April 2017 cannot be considered. Aggrieved thereby, the Deepali preferred another original application being OA 194 of 2024, in which the order dated 13th December 2024 was passed partly allowing Deepali's claim by directing the respondents to grant her remuneration since 1994, along with back wages and arrears within 3 months. Stop. However, the tribunal did not interfere with, did not issue any direction for reinstatement, observing inter alia that such benefit cannot be extended since, quote unquote, after due process of selection, the post of part-time sweeper has been filled up by another person. Unquote. Mr. Kundu submits. Mr. Kundu argues that such observation pertaining to the termination order as issued is self-contradictory, inasmuch as the service rendered by Deepali inasmuch as the respondents extracted the service of Deepali, notwithstanding a new incumbent having been inducted into a new incumbent, namely, what is the name of the? Namely,
Lalon Basfor.
where do you know?
In order, second page, in order,
In order, second page, which paragraph?
first paragraph, Mr. Royce. Second page, first paragraph, fourth line.
Irrespective of, notwithstanding the engagement of one Lalon Basford as a permanent sweeper in the said college. Since indisputably Deepali's services have been extracted even about 6 years thereafter, till she was illegally terminated with effect from 31st July 2017. According to Mr. Kundu, the state respondents having accepted the fact, according to Mr. Kundu, the state respondents did not prefer any appeal against the order dated 13th December 2024 in the original application being OA 194 of 2024. And thus it stands admitted by them that Deepali had been engaged in the year 1994 and had completed more than 10 years of service. Prior to the date specified in the government memo dated 23rd April 2010 as quote unquote 01.04 from 0.2010. সবকটাকে না numerical date unquote. Mr. Guho Rai, learned advocate appearing for the state respondents, however, denies and disputes the contention of Mr. Kundu and submits that no legally enforceable right of Deepali had been infringed by the order impugned, and that as such no interference is called for in the present writ petition. By the order, the learned tribunal had already granted benefit, extended the benefits of the government memo dated 23rd April 2010 till the date of her termination, till the date of her termination. He further submits that Deepali's engagement was subject to filling up the post on permanent basis by a competent person. Admittedly, one person has been appointed on permanent basis, and as such, question of continuance of Deepali in the said post does not occur, inasmuch as it was made clear in the initial order of appointment that her appointment would be till the filling up on the post on permanent basis. We have heard the learned advocates appearing for the respective parties and considered the materials on record. Stop. Indisputably, by the order dated 13th December 2024, the learned tribunal arrived at a finding that Deepali had rendered service for more than 10 years till 1st of April 2010, as indicated in the memo dated 23rd December 2004. The tribunal also arrived at a finding that subsequent thereto, services from Deepali was extracted till 31st of July 2007. Stop. No, till 30th. Stop. Admittedly, as a regular incumbent has joined the post at 31st July 2007. Stop. We do not find any nothing has been brought on record. Nothing has been brought on record in the affidavit in opposition filed by the state respondents, explaining the process of alleged termination of Deepali's services on and from 31st of July 2017, save and accept a statement to the effect as contained in paragraph 4 of Roman 4 bracketed Roman 3 of the affidavit in opposition. In the said paragraph, it has only been stated that Deepali was terminated with effect from 31st July 2017 by the college authority, as one Lalon Basford was appointed on permanent post of sweeper on 22nd July 2017. However, the respondents have failed to bring on record any such letter of termination. Bereft of such materials, the only conclusion which can be drawn by this court is that the respondents have in a most illegal manner disallowed Deepali from continuing in the post concerned without any formal order to that effect. There is no order of termination on record, and there is no explanation whatsoever as to how such a decision was taken, even without granting an opportunity of hearing to Deepali. It is well settled that even a temporary employee prior to termination is entitled to at least an opportunity of hearing. Such act of the respondents is clearly thus unsustainable in law. State is a model employer. It is for the state to ensure that his employees do not suffer on the rudiments of a purported rigmarole as regards application of different government orders. No, I don't state is a model employer কেটে দাও সে কেটে এবার লেখো as a model employer comma the state government must conduct itself with high probity and candor CANDOUR and ensure that its employees do not succumb to any discriminatory practice Stop. The learned tribunal, upon arriving at a finding that Dipali had rendered service on and from 1994 till 31st of July 2017, did not furnish appropriate reason as to why it did not go into the question of validity of the impugned order of termination dated 31st July 2017. In such circumstances, next part. Records reveal that pertaining to the illegal termination with effect from 31st of July 2017, litigations commenced on and from the year 2022 and had continued for a period of four years till date. In the midst thereof, Dipali could not render service as a staff of the said college. For such pendency of litigation, the state authorities cannot also be blamed. In view thereof, balancing the equities, in our opinion, it would be appropriate to direct the respondents to reinstate Dipali within a period of
4 weeks. 4 weeks. 4 weeks.
within a period of 4 weeks from date. Upon such reinstatement, Dipali shall be allowed to continue her services till she attains the age of superannuation of 60 years. And upon such superannuation, she shall also be entitled to the benefit of payment of an amount of rupees 1 lakh as provided in the memo dated 23rd December 2010. 4 weeks from the date of communication of this order. 4 weeks from the date of 4 weeks from the date of order. In the said it is however made clear that as Dipali had not worked during the period from 31st July 2017 till date, she would not be paid the remuneration pertaining to the said period from 31st July 2017 till the date of her appointment in terms of order. With the above observations and directions, the order passed by the learned tribunal is modified. No, the order of the learned the order of the learned tribunal is modified to effect. And the present writ is modified to the above effect. And the writ petition is disposed of. There's
Subsequent years, the benefit will be enhanced 1 lakh to 3 lakhs. 3 lakhs.
It was enhanced from 1 lakh to 2 lakhs and now it is 3 lakhs.
We have not mentioned the remuneration.
Last year said that 1 lakh rupees to be paid at superannuation. That has been subsequently enhanced.
Oh, that has been enhanced to how much?
Currently it is 3 lakhs. As per
আচ্ছা ওই লাইনটা কি লিখেছি বলো? However, the petitioner will be entitled to the benefit.
So payment of amount.
Na payment of the amount to which she is entitled in terms of the government orders. They will be good. Disposed of.
Amount of mention করা হলো না করলাম
Yeah, thank you, Mr. Yes, call the next. ইয়েতে করে দেবে শোন ওটা করে অভিজিৎকে বলে দাও ওটা করে পেন ড্রাইভটা করে আমার ল্যাপটপে একটু দিয়ে দাও একে তো পূর্ণ তো পারবে বলে একটু অ্যারেঞ্জ করে না ইয়েস আইটেম 20 ওয়াই ম্যাডাম
Please, on Monday, he will come physically before the judgment and this week.
নট দিস কবে আজকে কি সোমবার নট দিস উইক করে দাও ইয়েস নেক্সট দেখি অর্ডারটা
ইফেক্টিভ সেকশন 5
অ্যালাউ করে দিয়েছে অ্যালাউ করে দিও
ডিফেক্টিভটা তো ইয়ে হয়ে গেল ডিফেক্ট থাকছে
এই অর্ডার দিয়েছে পেপার বুক ফাইল করেছে কি এটা
আবার টাইম লাগে পেপার বুক ফাইল করার নট দিস উইক আর কি করা যাবে
Where is Navankar Pal? He was here in the morning. Who is Mr. Soumen Dotto? Rajendranath Badik, anybody knows?
not today থাকে কি কালকে
কিসের জন্য লিস্টেড আসবে শুধু শুধু
একটা ডাইরেক্ট এক্সটেনশন থাকে পেপার বুক ফাইল
আমরাই এক্সটেন্ড করে দিই নেক্সট ইয়েতে প্রিয়াতে করে দিতে আমাদের কাছে
কিন্তু আছে লিখা
আসবে আসবে টিচারটা ডিসমিস করুন দেখবেন সব ছুটে আসবে
এত হয়ে এলো সময় পর
Now, no one appears on behalf of the appellant and no accommodation has been sought for. In view thereof, the appeal is dismissed for default. Here is junior. Why, sir, people are not bothered? At least should come and say that this is to be done. Yes, Mr. Pal. You are happy that it has not been filed. Who is your friend? Other side? Soumen Dotto. Where is Mr. Dotto?
From the principal bench.
Now, who is Rajendranath Wadi? You don't know Rajendranath Wadi? No one appears today on no one appears today on behalf of the appellants, though Mr. Pal and an advocate appearing for the state is present. Mr. Pal apprises this court that no informal paper books, comma, as directed earlier, comma, has yet been filed. In view thereof, this the matter for further consideration. In view thereof, the matter stands adjourned as a last chance. List the matter for further consideration in the next available circuit bench. The appellants shall file the informal paper books in the meantime, with copy to Mr. Pal. আপনি ডিসমিস করতে চান, এইবার আগে ডিসমিসালটা উইথড্র করে দিন। Yes. Next.
At number 24.
Same. দেখি একটু ফাইলটা দেখো। Allow করে দিচ্ছি। Can one allow? Same order করে দিন। Yes, next.
Number 25. I would appeal. Matrimonial appeal. Ready. Paid the my dues as and the appellant husband.
For the husband, Mr. Roy.
Sometimes. I don't
So settle it out with your wife.
There's no scope. Mediation fails.
Fails.
Yes. I just say why I'm coming from. My lord.
So your option is divorce should be taken.
Yeah, because criminal case of 498 has been acquittal.
Nowadays,
406 acquittal. And this is what
nowadays
2003.
mediation is the point.
Mediation is, my lord, is fails. She asks for many.
For settlement.
Because about the instance of
No, are you ready and willing to take back your wife?
No. This is 2003, my lord.
Very well.
My lord,
You don't have the right to dismiss it as a irreconcilable effort for
2003, my lord, Somergo's judgment.
No, question is.
No, I have three.
This is a 100 pages judgment.
I'm show you the one paragraph. It's enough for me. I show my lord.
One will be enough, Mr.
They people yesterday, same thing happened in the justice Anta's room, my lord. So what I'm saying, my lord, can see 2003 that she left. Then I filed and it was 8 for divorce on the ground of mental cruelty. That was dismissed. She filed 419 application. I got the acquittal. She filed the application 406. That was I got acquittal.
Do you have any issues?
One child, female child, she's now major, she's staying with her mother. I gave the maintenance 6,000 rupees, but that was the dues on the earlier bench, said we should pay Mr. Roy, I paid.
Then what happened? Now it is ready for hearing.
It's ready for hearing, my lord. So my lord, 498, my lord, acquittal is sufficient for my mental health. I show the.
All right, come tomorrow, Mr. Roy.
Hearing,
এই তো দেখি ফাইলটা দাও
বড় বড় ম্যাটার
আপনি কি আপনি ফাইল আপনি দেখবেন
What is this can for? Can, all the so many can is there? What is this?
They file a can for payment of some payment. We have paid. These are
You
over.
have paid.
She.
Yes.
Payment.
You have got this amount.
yes, 1 lakh.
So on the 3 issues, in one matter, same thing happened. There, Somergo's judgment of paragraph 101. Say more than 23 years. Tomorrow, my lord.
Paperwork not prepared.
Yes. Fine, Everything is ready, my lord.
Document ওখানে গিয়ে দিতে হবে কোনো এত করে দেবে দিয়ে দেবে না
Matrimonial.
Your lordship gave a stay at the occasion. But initially I moved before lordship, the 5 lakhs cost that was stayed by your lordship.
Did we commit any mistake?
No, no.
Oh, we
Hmm.
rightly passed that order.
Well, a mistake, those are, please calm down, there's no mistake.
Mr. Roy, we would be reshuffling our list because we intend to take up these civil applications and order 41s and this civil application hearing. So tomorrow we cannot assure you, it will be there in the list. If it is taken up well and good, please get yourself prepared because this will take some time. How long will you take?
I'll take, I hold you the
Half an hour.
Saptangshu Vasu, Mr. Rai means the whole day. But
Not today, করে রেখে দাও।
I'm very bad ill favor I have now. Yes, madam.
Item number 3, Lord, item 3 of your lordship's list today. And my lord, this mentioning slip that I just handed over, my lord, they pertain to the same.
What have
case.
I done? Have I done anything?
No, my lord, nothing.
Then somebody else.
No, my lord.
He was-
Both these matters need to be heard together. They pertain to the same case diary, my lord, family members.
Yes.
Item 3.
Restoration. What?
Anticipatory bail, man.
You have served your other side. Yes, Thakur.
Item number 1. My lord, I am for the petition in item number 1, my lord. Allegation against us are under section 318, 336, 338 and 61, my lord. We are enjoying the protection of not to arrest, my lord. We have complied with the order of the coordinate bench of this court, my lord. We have joined the investigation.
You have not joined. That is the report of the state.
We have joined, my lord, already.
The state says that you have not done.
And already civil suits are pending, my lord.
Maybe, but you have. Why haven't you complied with the earlier direction?
My lord, we have joined, my lord. No copy has been given that we have. Kindly call for the CCTV footage of the local police station, whether I have joined or not, my lord.
My lord, I would state, my lord, the last
Ajay,
section already.
let me hear what is his matter. What is your matter?
My lord, these two petitioners purchased a land from two other accused persons, namely Nandalal Sharma and Sikandar Sharma. And these deeds are annexed, and this Sikandar Sharma and Nandalal Sharma purchased these two lands in question from the de facto complainant by virtue of a power of attorney, my lord. A power of attorney sold that land to my previous owners, my lord. Subsequent, and these two transactions were made in the year 2006, my lord. Deed are annexed at page number 52 to 78.
Very good. Then
Subsequently, my lord, co-accused number 5 and 6 of the main FIR, my lord.
okay, come to the earlier order. What was done? What did the court say? Earlier order, 9th of September. Yes, Mr. Chakraborty. What?
Power of attorney, the defective complaint is also here.
Civil disputes, sir.
Civil suits
they
are
went
pending
to
also, my lord.
They went, High Court also intervened, 226 was also done. Investigation over. Pending. Now, just you apprise me that you have, just that I find a letter from here given by inspector. So if they are saying that you have not gone, you were
And
caught.
my lord, another thing.
What
I
happened?
also suffered head injury, my lord. I was hospitalized. Kindly come to page number 109.
Why didn't you say those things to the earlier bench? Why didn't you say those things? এটা ওনাকে দিয়ে দাও, see the last paragraph of Mr. Chakraborty, this is your report. Show it to him. See the last paragraph.
My lord, IO has reported against me. It's true, my lord. But kindly, director.
It's true.
They have no. That's not my contention. IO has reported
Mr.
against me.
Chakraborty opposes you.
But my lord, kindly direct the investigating officer to produce CCTV.
Now I will direct CCTV footage for you.
I went there, my lord, but the report has gone against me, my lord. And whether I was there or not, for that reason, no hajira was obtained from me. Nothing was done by the IO, my lord. And civil disputes are there.
Who are you?
Whether they are bona fide.
Why he is so quiet?
That's the reason.
My lord, he shall open his mouth before the civil court. He has already opened his mouth in the
Whether they are the
civil court.
bona fide purchaser or not.
Yes, my lord.
My lord, forgery is taken place, my lord. And there is an order by this court, my lord, to hand over this power of attorney, all this, cooperate with that extent, my lord. He did not cooperate. If you
We
are
will
not,
ask him to go. We will ask him to go to the station. Ashok, apprehending, arrest in connection with such and such. The present application has been preferred. What's your name, sir?
I'm Sanjay Majumdar.
Mr. Mojumdar, learned advocate appearing for the petitioner submits that the petitioners have been falsely implicated. There had been an attempt on the part of the de facto complainant to criminalize a civil dispute pursuant to the earlier order passed by this court on 9th of September 2025. The petitioners cooperated with the investigating officer in the said conspectus. Custodial interrogation of the petitioners may not be necessary, more so when there is no possibility that the petitioners would flee from justice. Mr. Chakraborty, learned learned appearing for the state, however, disputes the contention of Mr. Mojumdar and submits that that investigation is still continuing. Mr. Poddar enters appearance on behalf of the de facto complainant and opposes the petitioner's prayer. Records reveal that pertaining to records reveal that there is an existing civil suit between the parties. Stop the petitioners herein also approach this court, this court, challenging an order of approach this court by filing a civil revision challenging an order of denial of
Injunction.
Denial of injunction
Subsequently, injunction was also granted, my lord.
by the High Court.
By the High Court. Status quo was given by the High
Stop.
Court.
It cannot be ruled out. It cannot in the said conspectus. It cannot be ruled out that the it cannot be ruled out that the dispute is civil. It cannot be ruled out.
Page 86.
That the dispute has been given a criminal profile, considering the nature of allegations, the extent of complicity, considering the gravity of the offense, the nature of allegations, and the extent of complicity of the petitioners in the complicity of the petitioners in the alleged offense. I am of the opinion that there is no necessity for any custodial interrogation. View thereof allowed 10,000 two suretities, one local. But Mr. Chakraborty, what is the usual now sureties that same?
Amount. That's up to my lord. That
10,000.
varies from the.
Acha, with a further condition that the petitioner number 1 shall
Duto. One and two.
shall meet with the investigating officer, once in a fortnight till completion of investigation.
Obliged, my lord.
Allowed. Yes. Yes. কোথায়? Give an extra copy to him. Just now.
Giving my copy to him, my lord.
So what happened? Voluminous you will not give him. So why haven't you given him? There was an earlier direction. তাহলে recall করে দাও. You are not giving. চল next. Yes, next.
My lord, this is an answer.
Yes.
I am for the petitioner, my lord. This case pertains to recovery of ganja.
এই রে.
My lord, I am coming. This is no recovery from me.
There is no recovery from me. I'm not named
Commercial,
in the FIR.
commercial.
Commercial, but not from me, not recovered from me. I'm not
You
connected.
fled away from this.
No, no, no. There is nothing in the FIR against me. No. I have gone through, carefully gone through the FIR. And the seizure list I have annexed, my lord, there is nothing. I did not flee.
Where's the statement?
Charge sheet file?
Yes, my lord. Fine. We'll face the trial.
What was ganja of how many kgs?
39.5.
Commercial is above 20, na?
Yes, my lord. I am not connected, man. It's not
How
recovered.
you are not connected?
I am not connected. Man, in the FIR, even I was not in the spot. In the FIR, kindly see, my lord. FIR against 2 persons, it was started.
Pradeep and Oni.
Yeah,
So you left the spot, you were driving the vehicle.
no, my lord.
What no?
I am not even the owner of the vehicle. But I will face the trial. I am a local resident, I will face the trial.
Ashok, apprehending as such and such, Mr. Learned advocate appearing for the petitioner submits that there had been no recovery of any contraband substance from the petitioner and he has been falsely implicated. Mr. Chakraborty, learned APP appearing for the state, however, opposes the petitioner's prayer and submits that the matter involves contraband substance above commercial quantity and the regards of section 37 of the NDPS Act may be at trial. Heard the learned advocates and having heard the learned advocates, considering the materials on record, it appears that the petitioner's name transpired on the basis of of co-accused statements, co-accused. Stop. Considering the extent of complicity of the petitioner, and as the regards of section 37 are not clear, complicity of the petitioner, I am of the opinion that custodial interrogation may not be necessary, more so when upon completion of investigation, charge sheet has been filed.
Yes, madam.
Allowed 10,002 securities, 1 local, with a further condition that the petitioner shall meet with the officer in charge of
Cyber police station.
Sahibganj police station once in a fortnight and shall attend the learned court below on all the dates of hearing in the event, all the dates of hearing. The other. Yes, next.
Three, my lord, for the petitioner.
Because I appear for the de facto complaint in Milord's
Lord, this is connected with the matter, my lord, that I mentioned in the afternoon session, sir.
Who is done?
This and the mentioning that I just.
Oh, that's it.
Yes. Kindly takes it up tomorrow, my lord, both the applications.
Both the cases are arising out of same PS case.
Yes.
Same case diary.
Family members, my lord. She is the wife and my lord, the husband and
What
the
that
son-
is submitted?
No, my lord.
Not yet, my lord. Charge sheet not submitted.
What is the allegation?
My lord, 406-420, civil dispute, my lord. I'll show it to you, lord.
Not today then.
Milords, may I request on Wednesday, Milords, if that's convenient to your lordship?
All right, sir. Wednesday.
Milords, subject to my friends, Milords. I'm grateful, Milords. Thank you.
Wednesday.
He should come. But he is not doing virtually. He should come. The other train was doing the
You
virtual.
call him on behalf of the court and tell him. Yes, next.
Grateful, Milords.
But I'm for the petition.
I am for the statement.
So you also before, I see the 2 orders by the earlier, the principal bench.
Principal bench.
Yeah.
Bullets.
Then I'll come to the points. One principal bench, this is 24th September 2005 order.
এটাতে একটু জল দিয়ে দিতে পারো।
একটা মেমো এটা মনে কাটতে হবে।
Order is there, my lord?
Yes, Mr. Roy.
And it's the 24th September's order, my lord. When I moved it, I'll give a copy of my order, my
24th?
September order.
Yes.
When I moved this petition before the principal bench, the order for not to arrest was given. Proceed.
Yes, you complied.
Yes, next page, take next order is at 4th November 2025. I complied with it.
4th November.
Yes, it's extended.
Yes, what is the allegation
Yes,
against?
I'm coming, madam. The petitioner was a bank manager of a Indian bank. There's a 244 self-help groups in Kujbihar. They're the account holders. There are two type of accounts, self-help groups, one loan accounts, one savings accounts. Allegation is that, my lord, there is embezzlement of more than 2 crores 250 lakhs rupees, and it's allegation that you, by sanctioning loan, you have misappropriated, or for the transfer of the fund from the one industry self-help group. Yeah, but there's no explanation. There are no evidence as to how I have embezzled. There's no, I can show. But
Have you been suspended?
Yes, I was present on suspension.
Departmental proceeding initiated?
No, they have
But he has
initiated.
been suspended.
No, I said, I was suspended. I just show you, Lordship. I had a suspension order. I was suspended, but entry was conducted on 13th September 2024. I was present on 12th December 2024. Thereafter, they did not take any steps. Now, when they have not filed a charge sheet, given a letter, then they filed a criminal case on 12 June 2025.
When was the incident?
The investigation conducted by them 13th September 2024.
Conducted by them means?
By the bank officers, the higher officials.
30th September?
13th September.
13th September 2025. 24.
Then they placed me under suspension 12 December 2024. But no charge has been filed. I given the letter. Now on 12 June 2025, they lost this FIR. After about 6 months after, there's no explanation given.
That you deal in your departmental proceeding.
But the department has not been initiated still now.
But what is the allegation against?
I
That
just-
you have this self-help group money, you have shown it as a loan.
No. I'm a bank manager. Self-help group has got the loan. This is allegation. Can you come to page 26 for a moment? That I show the order mile of the High Court. There's no money trail with me. Can you come to page 25?
What is this? 25?
The FIR mile. It starts at page 24. The 25 is the complaint mile. I just press it, mile. But there's no evidence. They can't show that I have missed up. But they say this is exchange of money between the self-help groups. I sanction a loan, but they have not given a report from the suspension order. And I need all documents to show that they can't say, even I'm not the list of the beneficiary. They have given only allegation, mere allegation. But paragraph 3 of the page 25, this is the allegation against me.
Yes, sir.
My lord, this is the case date. I'm sorry, my lord. There is not only one memo of evidence. Sorry, my lord, I have marked the important lines. Last paragraph. Page 3, last paragraph.
Charge sheet submitted?
Not yet, my lord. Investigation still in progress, my lord.
Is he cooperating?
He is cooperated. That is written in the memo of evidence, last page, my lord. Sorry, my lord, I have marked the Section 35(3) was served to the petition. He has complied with the investigation.
Apprehending Sergeant Mr. Roy Learned Advocate appearing for the petitioner submits that that a false allegation of embezzlement of funds have been leveled against the petitioner, who happened to be the branch manager of
my lord, Kalmati branch, Indian Bank. Kalmati branch.
against the petitioners to who happens to be the caterer. Stop. Submits that. Was alleged against the petitioner. Stop. And the criminal proceeding and the complaint was lodged about 8 months after he was suspended. After he was suspended by an order dated 12th October 2025. Stop. Pursuant to the earlier orders passed by coordinate bench of this court, the petitioner had rendered all cooperation and had met with the investigating officer as and when directed. Stop. Mr. Acharya, learned advocate, appearing for the answering our query, Mr. Acharya, learned advocate, appearing for the state submits that the pursuant to the earlier order, the petitioner did appear before the investigating officer, however, investigation is still continuing. Having heard the learned advocates and considering the materials on record, the nature of allegations, the extent of complicity of the petitioner in the alleged offense and his conduct, I am of the opinion that custodial interrogation may not be. I am of the opinion custodial interrogation is not necessary. এটা যখন নিচ্ছে না, আমার মনে হচ্ছে আমাকে পেন ড্রাইভে ফটোটা তুমি দিয়ে দাও, আমি দেখে নিয়ে তোমাকে পাঠিয়ে দিয়ে পে করে আমার কষ্ট হচ্ছে। আমার কাছে ইয়েটাকে নিয়ে এই পূরণটা পারে না। তুমি একটু ওদেরকে বলে দাও নিচ্ছ পেন ড্রাইভে আমার ল্যাপটপে আমি দেখে দেবো, নিয়ে নাও করে দাও। একটু পড়বে লাস্টের থেকে। Interrogation of the petitioner may not be necessary. Accordingly, we direct that in the event of arrest, petitioner subject to the satisfaction, subject to satisfaction.
The arresting officer, right? Because the investigation is in progress.
Arresting officer and other conditions with that is 482, na? BNS?
Yes,
yes,
BNS 482.
ওকেও বলে দিই ওটা ঢুকিয়ে দিতে। Other conditions with a further condition that the petitioner shall meet with the investigating officers once a week till such investigation is completed and shall reside in the cost title.
My lord, he is in posted Malda, my lord.
Malda?
Yes, my lord, he has come to Kuchibihar. He is under suspension. He is posted Malda, so with the leave he is coming.
Till the meet with the once a week until further orders. Till investigation is completed. Allowed.
Item number 5. My lord, I am for the petitioner item number 5, my lord.
I appear for the defect of complaint.
My lord, I have been protected by an order of not to arrest, my lord, and I was directed to cooperate with the investigating officer, which I have duly followed, my lord. And
that was passed by another bill.
Yes, my lord.
Yeah.
allegation against me is of cheating, that is 318, criminal intimidation 351 and 61 for conspiracy, my lord. Allegedly, I issued a check in the year 2023, which was dishonored. After 2 years of the dishonor of the said check, they have filed written complaint against me, my lord. This is the first thing. Secondly, this issuance of check, allegedly issuance of this check is relating to the sale of my flat. As per their allegation, my lord, I took money from them. I didn't give the registry to them. And subsequently, when I returned the money through check, that was dishonored. But my lord, kindly come to page number 12. They were pressurizing me to collect money from me. I have annexed my application before the concerned police station when they were pressurizing me, my lord. This is the first thing. Secondly, my lord.
Have you paid it back?
No, my lord.
Then when will you pay?
My lord, it's a delayed FIR, my lord. And
Oh,
civil suit is also pending.
So
my
you
lord.
are not required to pay?
No, I'll pay. My lord, civil suit is also.
You will pay.
After the order of the London civil judge, because they have filed a money suit
So
against.
I will mention that at the time interest will be taken into consideration, commercial rate of interest on the amount to be
My
refunded.
lord, already a civil suit is pending, my lord.
No, you said na that I will not return till the civil suit is over. Pay the money. Otherwise, I will give anticipated bill, but I will make a remark that it will be, if it is established, then you have to pay commercial rate interest. Choice is yours. Or you decide pay, finished, stop it.
My lord, civil suit is pending, so.
Sir, what is the amount? 14 lakhs or not?
22 lakhs, my lord.
22 lakhs. Not a bad proposal, I suppose.
My lord, if they can establish that they are entitled.
Yes, if they establish.
If they establish.
Commercial rate of interest. Don't say that. You are saying that I will wait for the civil.
They filed
Civil dispute, criminal profile.
Yes, my lord.
Yes, I will give you bail, but on this condition.
But my lord, commercial interest is will be too harsh for me, my lord.
Settle it amount, settle the thing.
Yes, when the dispute is of civil in nature, we shall try.
You have taken the money, admitted. Your check had bounced. Forget about what are the legalities, NI Act, etc., etc. So you will take, you are admitting that I've taken the amount. So why will you not refund?
Is there allegation that?
No, you just now said that yes, I've taken the amount.
My lord, it's their allegation that I have taken the money from them regarding the registration.
Now you said, no, I have taken the amount, I have not refunded it. Tell me how much you do, or I will ask him to show.
They already have filed civil suit, my lord. With that regard, if they can establish that they are entitled to get money, I shall pay the money.
They have paid the money for taking a flat.
Lordship.
This much is admitted. So when you have taken the money, sir, if you are not being able to give the flat, give them the return. Neither they would be disturbed, not the unnecessarily the state people will be disturbed. Settle it.
We are trying to settle this, my lord.
What is the amount?
22 lakhs, my lord.
Since 2022. And they responded to Kathmandu. It is their admission that they were in Kathmandu absconding.
Then thereafter, my lord, we have.
Charge sheet file, Mr. Chakraborty. Charge sheet file. Talk with your client, come back.
My lord.
Charge sheet pending, my lord.
I have cooperated with the investigating officer. That I have done, my lord. I have joined the investigation.
That report is there, my lord.
Came one day and thereafter my lord again absconding.
No,
So why civil suit? Why civil suit?
They have filed recovery of money.
You didn't file NI Act. Case.
That has
No,
also
no,
been filed.
NI
No, nothing has been filed.
My instructor, yes, because
Civil suit is pending.
summons could not be because they are not there. They were in Kathmandu. So the summons of the NIA case, what my instruction is, could not be served upon them.
We have received the summons of money suit also, my lord.
They were in Kathmandu. It is their admission that they were in Kathmandu.
For some period.
Only after it was brought to the kind attention of the honorable court, they came once
and then again they're responding.
We are in Siliguri, my lord.
Because
We have
a couple of days back.
So what you
My lord,
given to the
what I could learn, my lord, from the submissions of both the parties, thing is that this is obviously the civil suit is under the specific relief act on the basis of specific performance of contract. Now the vital point is readiness and willingness to pay and why they did not pay and even why the entire amount was not paid, why registration was not done. So these are the matters, my lord. Regarding report was called for, we have submitted the report.
And the difficulty is, my lord, money was taken.
Why didn't you tell the earlier court?
My lord, everything was submitted, my lord, before the honorable court, my lord. And it was, my lord, on because.
Oh, they have paid 22 lakhs.
I have paid the de facto.
Oh.
And my lord, the money was taken because she wanted to pay to the bank. She had defaulted in her loan and also to the promoter. Now she has not paid both of them. Now I am not even able to get the flat, neither the money. And thereafter, my lord, they've gone to Kathmandu. And it is their submission, my lord. See the earlier order.
For some period I was in Kathmandu, that I also admit, my lord. For some period of time I was in Kathmandu. Subsequently I came in Siliguri.
That finds no reflection in the petition, my lord.
Subsequently I came in Siliguri. I have
In the suit file, you have filed a suit for specific
Yes,
purpose.
specific purpose.
I did.
They have filed, my lord.
I have. What could be done, my lord, because such a huge amount is pending, my lord.
We have also appeared in the civil suit also, my
At
lord.
that point of time, they were there. But thereafter, my lord, the phone numbers are switched off, they are not there.
At present, he is in Siliguri. Both the
So the
petitioners are in
intention is,
Siliguri.
my lord.
And we have already.
Sir, how can we help you, sir? On the basis of agreement, the suit has been filed.
Yes, my lord.
But, my lord, yes, but my humble submission is that the criminality.
We could have sorted it out, but the thing is that you have filed a suit.
Yes.
Civil
Civil suit is
suit
there,
is
my
May
lord.
I, my lord, take such instruction that whether they've used any written statement there or not?
You, sir.
These are the reasons in one issue, 3 cases. These are the issues why for the black law 360 years more required. The total number of cases, pending cases is India. If you want to dispose of another 360 or more years are required, my lord.
My lord, if no
So
cases-
that's
if no
why
cases-
in one issue, whatever it is, ma'am.
If no cases are filed at all, my lord, then would be any backlog. But I don't have any other profession to pursue.
Mr. Chokworth is very worried about that.
I don't have any other profession.
Just a scene manner on article, it was written that
It could be
30% vacancy in the high courts, 60% or 40% in the
15% is for the non-appearance of the advocates in time.
particularly from the prosecution side.
I can give you the data
my lord.
that it came about my children ago. In the High Court records, 50,000 old matters, a paper reporting came out.
Item number 6.
Item number 6, I beg to appear on behalf of the petitioner.
One the accommodation and because the postmortem report is we are collecting the postmortem
Not
report.
today, yes, next.
Number 7.
Not. 7.
I am for the petitioner.
Instructed to appear on behalf of the de facto complement.
This is different from this petitioner. They do have voice. My lord.
Suspended or not suspended as yet?
Who?
Are you being suspended?
Not
No.
suspended and he's absconded till date.
Not suspended, my lord. No, I am not absconding, man. I'm pursuing legal remedies. So long I am pursuing my legal
Yes,
remedies.
yes.
Well,
You are the wife.
I'm the wife.
I'm the husband, man. The story is that there was the first case, there was a 498A after the marriage, man. After that, both the parties went for mediation, my lord. It was settled amicably during the mediation. The husband sent his mother to bring her back because he was away on duty. She came back. After that, she alleges that she was beaten black and blue. There was a demand of a dowry. She was beaten black and blue. And ultimately, this case has been registered with all the in the name of all the family members, including the husband. Now, all the other accused persons have already been granted anticipatory bail from the Kuch Bihar District Judge, page 18, my lord, District Judge Kuch Bihar, page 18, Annexure 5, my lord.
You are in rapid action force.
Yes, my lord.
Huh?
I am posted in Dabgram Fulbari, my lord. I'm coming to that, my lord.
So why you have been so unkind to your wife?
No, I am not unkind, my lord. These are all self-inflicted injuries. If she has some photographs in the writ
She
proceeding,
will stay in your house and make self-inflicted injury.
my lord, I will come to that. All other accused persons have already been granted bail, my lord.
Maybe.
My lord.
When
What
was
is
your marriage? When was your marriage?
it was, my lord,
In the year 2024.
2024, my lord.
Any issue?
No, my lord. Nothing.
Yes, now what happened?
My lord, now the FIR shows that the date of incident on the basis of which I have twofold submission. Number one, the date of incident is 28/5/2025.
28.
28/5/2025, my lord.
Very
This
good.
is the Raat 12:00, 12 o'clock. 12 at night is the time of incident. 12:00 থেকে 12:30 as per the FIR, my lord. Now I am posted in Dabgram Fulbari in Rapid Action Force, my lord, as a sub-inspector, my lord.
You were in Prime Minister.
Yes, my lord. Yes, my lord. That is,
How do you substantiate this alibi?
I have given my CC. I have attached my CC, my lord.
CC?
Command certificate.
Where?
It is Annexure P3, page 15 and 16, my lord. Page 15, 16 and 17. Here is the CC, my lord.
What is your name?
My name is, one second, madam. My name is Torun Bormon. It is 2 in the detailment of the officers list. It is Torun Bormon, item number 2 at page 16, my lord.
What is LNH? L/H remarks? Detailment of officers will be ID.
This is something rank and who will be in charge and
29th May. Incident was on 28th May at 12 noon. At
12
PM.
p.m.
Night.
Night, my lord. Midnight, my lord. Then now the CC, kindly come to page number 15, my lord. In every CC, there is an endorsement. I received the CC on 27/5/2025, my lord. I reported along with my battalion. I was not alone, my lord. Along with my battalion, I reported the inspector, the SP Alipurdwar on 27/5/2025, my lord. Here is the endorsement with the seal, my reporting endorsement, my lord.
That is a matter of trial, sir.
Maybe, my lord, but at this stage, my lord, my liberty is in question, my lord. My liberty is in question.
You are attending your duties.
My lord?
You are absconding.
No, I was attending my duties. Now I'm not joining my duties. I have other health issues also. That is not, I could not join my duties. I have informed my department accordingly, my lord.
Show us the injury report, Mr.
And my second point
Yes.
is on the injuries. Why am I submitting on injury, my lord? A writ petition was filed seeking proper investigation by the de facto complainant. Proper investigation, the IO was changed subsequently. We appeared, my lord. We also made submissions that we supported their submission. A proper investigation, a fair investigation is necessary. Now, my lord, because these points were not considered by the earlier investigating officer. From the annexures of the writ petition, I came to know about the injuries, my lord, which they filed. I found some documents of private testing labs, private hospitals, my lord. I didn't find a single government document in the annexures showing the injury report.
You filed writ petition.
No, they filed a writ petition.
It's a very writ petition. Where is that order?
My lord, the order.
I have a copy of the order.
What did the court say?
This is the order.
Here is the order, ma'am.
Petition was disposed of by directing the superintendent of police for a change of investigating officer.
And that change has been done.
Change has done, but lordship kindly see if the submissions which has been made by my learned friend with regard to the.
We shall come
Yes,
back
your
to
lordship.
this.
Yes, your lordship.
And the allegation is about 307 and 326 grievous hurt. There must be some kind of injury like that, my lord.
Yes, to that what you are saying?
My lord, the documents that all private hospital documents, there is no, the documents are not sufficient to substantiate a 307 charge, my lord. As so far I found in the document, the rest of the learned PP will be assisting your lordship on this point. I have no further access.
The injury report from the government hospital now.
There must be some fracture to it.
Just that I appear.
My lord. ছুড়ে গেছে।
Yes, madam.
My lord,
Anything else you want to show?
On last occasion, there was a direction of the report by the concerned police station for his duty and all these things.
I see.
And somebody said report, my lord.
What did
On
they say?
26, my lord, on 26, duty has assigned. On 27, he joined. And my lord, as per the report, my lord, 28, there is no duty.
But he
And
was in the
29
PA.
As a partition duty, he performed the permission.
No, no, 28, what happened?
28, there was no duty, but he already on
Deployment.
role. But there is no duty. There
But
is
he was there in his station.
no, that is not specific.
Oh.
That is not specific.
He cannot go on roll call
Sir,
system.
we have heard you.
My lord, I apologize, my lord.
26, the memo has passed, and apparently on 27, he joined. Report is there.
27th he joined.
Yes.
Detailment order was on
Last-
27th.
Yes, 20, yes, madam. This annexure is there with the report, madam. And 29, 28 is a duty period, but there is no duty, government duty. And 29, he performed the partition duty.
Yes,
so lordship, as my lord he stated.
Charge
the
sheet
CC
submitted now.
No, give me CC.
The CC which he has shown, my lord, that is in respect of, my lord, the date 29. Now, my lord, public prosecutor has.
Your
my lord-
duty report, madam.
Yes, lordship. Kindly see these documents, lordship. Once
But-
lordship go through the photographs, lordship.
This is the.
My lord, I don't know whether, my lord, I afraid these are not in the CD. Lordship,
This is in the
kindly see, this is it.
CD.
These photographs, my lord.
No, no, photographs.
Now, lordship, kindly see.
Don't show us photographs, madam, because.
Lordship, I am not showing. I am showing the, my lord, the injury which he sustained. It is, my lord, issued from the government hospital where she was admitted to Conjunctive hospital. My lord, lordship, kindly see. Trauma in head, upper, lower limb, chest. Now, my lord, he said, my lord, that some of the treatment prescriptions are from the private hospitals.
We are not on that.
My lord, I am also not on that. But this is not true. She was admitted in the hospital, government hospital. Lordship knows very well that these government hospitals does not have, my lord, these kind of facilities of, my lord, ENT facility. She has lost, my lord, partial hearing capacity and partial, my lord, eyesight. My lord, these tests have been made from the private or the private in the medical institution, but that has been lodged while she was admitted in the hospital. While she was admitted in the government hospital, since this government hospital does not have this kind of facility of examinations of the hearing or the eyesight, so she was, my lord, referred to this private hospital, medical institution, where she was examined, and it was found. It was found that, my lord, she has lost partial eyesight and, my lord, the hearing capacity, lordship. My lord, there are also photographs, since your lordship is not all the photographs.
We are usually do not put photographs.
Just see, my lord, your lordships do not take into consideration.
I've seen the photo.
even photograph the finally.
Lordships, see the history reports, lords.
Madam, we cannot go beyond the case.
My lord, yes. Lordships, the main and principal plea of the petitioner was the alibi. Now, lordships, from the document which he has shown to your lordship, which is called CC, that CC is only with regard to the date 29.
No, my lord.
The report.
Where are you posted now?
I'm in Dabgram, my lord.
Huh?
Dabgram only, my lord.
Where is that?
It is in nearby Shiliguri.
And where is she residing?
Tufangas, my lord, far away.
You are with your parents now.
Yes, of course, lords. And now
She lives in maternal uncle's.
the report, my lord, which my learned, my lord, public prosecutor has been submitted to your lordships, from which your lordships will see that on 20th he has no duty, and where he was, that was not cleared in the report. My specific submissions before your lordship is this: on 28th he came back to his house. She tortured the wife brutally. On 29th she again joined to the duty. So the
Apprehending Alice. Learned advocate appealing for the petitioner submits that the petitioner made it, the complaint was by you, madam, or by us? That the petitioner made it the de facto complainant on 12th of no. When was your marriage?
2024, madam.
In the month
12th
of
of
February
February
2020.
12 February 2024.
I've heard it. You will. The month of 2024 and Mr. Saran, the advocate appearing for the petitioner submits that the petitioner you are posted at
Dabgram, 2nd Battalion, Dabgram, RAF. RAF, 2nd Battalion at Dabgram.
you are, what is your designation?
SI, Sub-Inspector of Police, Armed Police.
Petitioner is the petitioner is presently posted as an assistant sub-inspector at Dabgram, DAB.
Assistant, not man, Sub-Inspector. DAB, Dab, GRM, Dabgram.
Dabgram district.
This is a 2nd Battalion within district, Jalpaiguri district.
No, Mr. Learned advocate appearing for the petitioner submits that the petitioner has been falsely implicated on the rudiments of a falsely implicated. The allegations leveled against him are absolutely unfounded. Are absolutely unfounded. And in such circumstances, custodial interrogation may not be necessary. Such contention has, however, been disputed by Ms. advocate appearing for the facto complainant. ওইটার আগে আরেকটা দিয়ে দাও, he further submits the atrocity date of the alleged on the date of the alleged incident. He was deputed to the duty of the Honorable Prime Minister on 29th of May 2025. Such contention has, however, been disputed by several learned advocate appearing for de facto complainant. She submits that the petitioner had tortured her, and which led to severe injuries, severe injuries. And the incident occurred within about a year, after marriage, within a year after marriage. Stop. She was also tortured by her in-laws. And in such and the in-laws. Stop. And the complaint tortured by her in-laws. Stop. She submits the next paragraph. Mr. Chakraborty BP appearing for the state has placed before this court. Any report was called for?
Yes, last connection.
So it was placed before this court. Report before this court pursuant to the earlier direction passed by this court. Let the same as far as immediate record. In the report filed today, it has inter alia been stated on 28th May 2025. The petitioner was not detained for any kind of government duty, however, on 29th May 2025, the petitioner took up the duty post at 8 hours and after the stand down at 3:25 hours. You join duty post at 8 hours. Stop. Has he? You didn't call him for your investigation is still continuing.
I will cooperate with the investigation. I'll cooperate with the investigation.
I have a hard time having heard the learned fix. Having heard the learned fix the nature of acquisitions. The extent of complicity of the petitioner and the injury reports. I am of the opinion that custodial interrogation may not be necessary. However, the petitioner's movement needs to be restricted. Accordingly, allow 10,000 crucialities to one local with a further condition that the petitioner shall meet with the investigating officer once a week till investigation is complete. Once a week till investigation is complete.
Obliged.
Item number 8.
Madam for the petition. Oh, sorry. Nice. Sorry.
Milord, I am for the petitioner, Milord. We are three petitioners, Milord. Allegation against me, us were, Milord. That petitioner number 1 left the house 2 months back, Milord. And when this deceased visited her to take this service place, Milord, he had been assaulted and mentally harassed by her father and brother, Milord. And in this matter, Milord, this charge sheet has already been filed, Milord. And thereafter, after the filing of the charge sheet, Milord, this ACGM Court of Correction had issued summon, Milord. I went to this ACGM Court, Milord, but ACGM Court didn't take my application, stating that this case is triable by the session judge, Milord. Thereafter, I went to the Sessions Court, Darjeeling, Milord, and on Milord 10/10/2025 on the ground of maintainability, Milord, my bail application was rejected, Milord. So that is the reason, Milord, I have come before your lordship court, Milord.
Bail was rejected.
Dismissed on the ground of maintainability. Yes, Milord. And
No,
there
you said that you went before the proper forum.
no, Milord. Actually, after the filing of the charge sheet, Milord, this by the IO, Milord.
Oh, charge sheet has
Yes,
been filed.
yes, Milord. And we
What
have
is
been
the allegation against you?
Milord, may I read?
Is the husband minor and the accused persons are minor, the wife, the father, and the brother of this deceased, or brother-in-law of the deceased.
The allegations are, my lord.
Accused is the Indira is the wife. Wife and Pradeep is
It is the father of this Indira.
in the other is father-in-law. Father-in-law and brother-in-law.
The
I
allegation
see.
is that on 23rd 6 2025, complainant was informed that his nephew committed suicide and his sister-in-law was staying separately from his husband, and when sorry, to take back into that country, his father and brother physically assaulted him and was mentally tortured him, to which my lord he committed suicide.
She came back and committed.
So he came back to his place, my lord, then he committed suicide.
No, there
Who committed? The husband committed. my
On
lord.
the same date.
No.
My lord,
There's no date mentioned.
Yeah, just a moment.
the PM report, my lord, is that 24, so that is that. 15/6/25. Date of incident is the my lord, actually after the incident, they are filed a complaint.
After the incident, we
15/6/25, like complaint suicide on 23/6/25, the
15/6/25 was the incident.
Alleged incident.
And the complaint was lodged.
23/6/25.
That is about a week thereafter. Now charge sheet has been submitted. The allegation was that she was
married to this person.
she was married when? Married when?
16 years back.
16 years ago.
They have a daughter of 16 years. Presently studying in class 11.
So you were living separately?
Separately for the period
So
of.
where was your daughter? With your with the father or with you?
With me only.
Oh.
This deceased was staying at Sukuna, Milord, and she was staying at Kurseong for the education of her daughter. But they have a family discord, Milord, this dispute, Milord.
Apprehending is the present application as well. Learned advocate appearing for the petitioner submits that the petitioner married the victim 16 years
back.
16 years back, and from such matrimonial relationship, they have a daughter who is presently
studying in class 11 at
studying in
St.
class
Alphonsus School.
Studying in class 11. Due to a matrimonial discord, the petitioner was living separately along with her daughter. The allegations are omnibus in nature, and the complaint was lodged. And the alleged complaint was also lodged belatedly in the said conspectus. Custodial interrogation may not be necessary, more so when upon completion of investigation, charge sheet has already been submitted. He further submits that not only the petitioner, but he further submits that by the present complaint was lodged by one
Sorin Lamgade, uncle of the deceased.
By the uncle of the deceased, incorporating allegations against the father-in-law and brother-in-law of the deceased. Mr. Samkumar, learned advocate appearing for the state, submits that upon denies the contention of the petitioner and submits that there are incriminating materials on record against the petitioner. Having heard the learned advocates, the nature of acquisitions, the extent of nature of acquisitions, the extent of complicity of the petitioners, কি লিখলেন? The extent of complicity of the petitioners and as upon completion of investigation, charge sheet has already been submitted. I am of the opinion that custodial interrogation may not be necessary. Accordingly, 10,002 sureties on local subject to the satisfaction of the arresting officer and other conditions in section 482(2). Allowed. Yes.
Number 9, not answer. But allegation. Short person, my lord, Mr. Neelachal, so another pro.
Yes, next.
Number 10.
My lordship, in this matter, all these co-accused is on bail and the charge sheet has been filed. The petitioner is included in this case due to prior assumption only. He was not presented at the place of occurrences.
Yeah, who is
What is
appealing?
the vision, my lord? We are calling.
But Foreigners Act.
No, my lordship. It includes under section 447, 188, 186, 350, 353.
What are, yes.
And such as section with read with section 11 subsection 1 subsection D of the Prevention of Cruelty to Animal Act.
Where is the injury report? Password. Yes.
For the petitioner. Our case is under section 448, 326, 307, 506 of the Indian Penal Code, my lord. Due to a land dispute, present FIR has been propped up, my lord. 5 person has been FIR named. Out of 5, 3 person has.
What, this grievous hurt?
My lord, previous. And my lord, 307 is also.
My lord, in IPC, my lord, in IPC, my lord, 448, 326, 307, 506, 30.
My lord, all the other accused person have been granted bail except the present petitioner.
What is the story?
Charge sheet has already been submitted.
Charge sheet submitted?
My lord.
Yeah, Mr. Acharya, what is the injury report? Injury report?
Page 33 and 34, the 2 injury reports are there, my lord, in the case diary. Abrasion is there, my lord.
33 and
33 and 34.
One of the story is that the present petitioner along with other 4 accused person enter into the land of the de facto complainant and thereafter, my lord, allegation of assault.
My lord, 161 statement of the victim is there, my lord. Page 30. 30. Name the petitioner.
No 164?
No 161 statement. Only 161.
Who is the petitioner?
My lord.
Name of
the petitioner, my lord.
Inzamul, my lord.
Inzamul Alam.
Mr. Acharya, injury report
shows 33 and 34.
Yes, yes.
Abrasion. I have seen, my lord.
Charge sheet submitted. Apprehending address, Mr. Roy, learned advocate, Good. Learned advocate appearing for the petitioner submits that the petitioner has been falsely implicated. And the allegations are in the abstract. Stop upon completion of investigation, charge sheet has also been submitted and as such, custodial interrogation may not be necessary. Mr. Acharya, learned advocate, opposes such contention of the petitioner and draws the attention and this court to the injury report and the statement of the
161 statement of the victim. Name the petitioner.
Having heard the learned advocates and considering the materials on record, the nature and gravity of the offense, the role attributed to the petitioner, and the injury reports. I am of the opinion that custodial interrogation may not be necessary, more so when upon completion of investigation, charge sheet has been submitted. Accordingly, allow 10,000 2 CODTs, 1 local, 482 condition with 482 conditions. Stop. Allowed. Yes. Next. Password is no.
12. For 10.
All right, next.
Case diary is not available.
Yeah.
Hey. Copy
Day after tomorrow.
But what happens in 10, my lord, they have filed it with the wrong police, with the name
Very
of
good.
police
Come
was
day
wrongly
after.
written.
All right.
We've already rectified it or
But
26 November.
that has not been clarified there in.
What you are saying? You've gone through the brief now.
Yes.
Yes, my lordship.
CD
They
will
already-
be required.
they were
We'll
present-
call for the CD. Give me the correct police station and the case number correctly written, we'll call.
We'll hand you the copy today.
Give a handwritten note. Give me a handwritten note.
Tomorrow?
Day after, man. It will come from Kujbihar district, I think.
All right, day after tomorrow.
Yes.
You cannot get it tomorrow.
But I have to send message from the office. And thereafter they will.
What is the allegation against you? What did you say?
কালকে দুপুরে তো করো না।
Section allegations under section 447.
All right, come back tomorrow. He will make an endeavor.
Give me the.
Yes, next item.
12.
12.
I am applying for this case.
Yes, tell us.
Part 306-34 of the Indian Penal Code. The petitioner is a lady of 40 years.
এই একটু এখান থেকে এগুলো বের করে দেবে বিএনএস টা বের করে বিএনএস আর
No, that was murder. This is a case of murder 2018.
আইপিসি টা আছে আইপিসি টা আছে না ওটা তো আইপিসি টা নেই না আছে এখানে আছে নাকি গো হ্যাঁ এই যে নিচে আইপিসি টা আছে 406
306-34. But instigate to commit suicide. 306. Petitioner is a lady of 40 years. Allegation is that she had a extramarital affair with one Biplab Mondal. Due to such reason, her husband had committed suicide. The lady has 3 children.
Charge sheet was filed in 2011.
21.
2021.
He's absconding.
What happened, The petitioner is a small tea seller, He has a tea stall, 3 children,
4 years. 4 years.
He did not, police did not went to the
obtain regular bail.
Kindly, she's a lady. She had 2 minor children, she had 2 minor children, but she had to look after
that is not an
explanation. Depend, kindly at any condition, I'll cooperate with the investigation. Kindly see, what is my allegation?
Is not proper. No?
Kindly see what is my allegation, kindly see what is my role.
What is your explanation? 21 to 26. 5 বছর.
That is
go and obtain regular bail matters. Surrender and obtain.
My minor children are absolutely dependent upon her.
Withdrawn.
Withdrawn.
On the prayer Sorry, Mr. Ajadjo, withdraw. The only Mr. Learned advocate appearing for the on the prayer of Mr. Learned advocate appearing for the petitioner, the application is dismissed as withdrawn. Yes, next.
Loading 13 app.
13, yes.
Yes, ma'am. Lord, petition for anticipatory bail. Lord, I'm not named in the FIR. Lord, a 67 notice was communicated to me. Lord, at annexure P1 at page 14.
You went?
No, my lord. This is the difficulty, my lord, because I happen to, my lord.
What is the allegation?
My lord, 9,000 bottles of cough syrup were recovered from 3 individuals. My lord, I happen to have drug licenses which are, my lord, renewed till the month of November 2026. I have all the, my lord, papers. But, my lord, since the NDPS officer has sent me this notice, my lord, kindly grants me this anticipatory bill, my lord, I'll go and comply with the 67 notice. That is all I'm praying for.
Why? Extra premium cannot be given.
Lord, then grants me a protection to arrest me, Lord. Let me go and comply with the notice. Lord, all the I have just submitted those documents.
You are not at this part.
No, my lord.
Your name transferred.
But from the but I'm just interrupting, my lord, from the GST certificate, the GST number, the name of the present petitioner is taxpayers. And the
GST number in what?
GST number of the medical.
Oh, achha. The commodities.
Yes. And thereafter, that should be asserted.
He was it was purchased from him.
No, I happen to be the consignee.
He is the consignee. Present accused person is the consignee. Consignor is the other person.
The consignor has not been intercepted.
Yes, no. Nobody is, my lord, arrested.
In fact, not the persons who were apparently apprehended at the spot, they also fled away. They have also been not been arrested.
Nazimul Haq transferred the article to the Sunil Jain with the GST number of present petitioner.
Nazimul gave it to
Sunil Jain. And they are the racket, my lord. They are the racket. Nobody is arrested.
Now the GST was in the name
of the present petitioner.
Why?
From the consignment voucher, it was asserted, my lord.
Lord, this is my consignment, so that will naturally appear there. These are all the papers that I have, my lord. My GST returns are
No, this
also.
consignment, you asked Nazimul to deliver it to
No, my lord. That instructions I have to take. I had a consignment coming, which was, my lord, for some reason apprehended by the GRP. And, my lord, the GRP.
No, you were the consignee.
Yes, my lord.
So you must have sent the material on the basis of your certificate, which you're running a.
I'm sorry, my lord. On that spot, I was the consignor. I happened to, my lord.
My lord, just this is a pencil mark point, my lord. Pencil mark point.
All these documents, my lord, are
from this. The name of has transferred. Shaha Enterprise. He is the proprietor of Shaha Enterprise. Present petitioner.
So does he have the appropriate paperwork for running this?
That should be asserted, my lord, from drug control and, my lord, the GST department, my lord. That has already
but
said.
He has to produce those documents.
Yes.
That is section 67 notice issued.
Yes, my lord. Yes.
Lord, I just submitted those papers, my lord. My drug license renewals are.
No, but where is that 67 notice?
My lord, at page 14.
That should be complied.
I will comply. But
You will comply after obtaining anticipatory bail.
My lord, protection to arrest, my lord.
What protection you want?
To me, my lord.
Apprehensive.
My lord, this is an NDPS offense, my lord. Kindly considers. I being a my lord, authorized reseller, authorized consignor, my lord. If I am arrested by these by the police person,
you show me.
Lord, I I've just submitted the papers, my lord.
What papers?
My lord, the first document is my drug license, which was issued to me in the year 2016 to 2021.
Now, do you have the permission to send any consignment of above commercial limit?
Yes, my lord.
No?
These are the licenses for dealing in drugs and cosmetics. And my lord, sees the last paper, the third last document, my lord. Receipt number
No,
1766.
who is the investigating officer? Mr. Chakraborty?
Yeah, my lord, investigating officer, my lord,
In Kuch Bihar.
Yes, that one.
Yes. But how I am to ascertain whether these are valid documents or
Lord,
not?
that is exactly what I'm saying, my lord. I'll go and produce this.
Then what is the effect of section 67? If everybody after receiving 67 comes to court, if you are arrested, go and obtain bail on the basis of
My
these
lord,
documents.
I should not be arrested, my lord. That is all I'm praying.
Then very good, sir. You
My
will
lord,
not be
if the
arrested.
report is adverse, my lord, if the report is adverse after I appear before the investigating officer, my lord will consider that and not grant me the anticipatory bail. But for the time being, when I'm wanting to visit the officer, my lord, I'm only wanting a protection.
What is the reason that it, sir, is that any proposition
an
that
NDPS.
say once a notice is issued, I will go to obtain an anticipatory and then go to?
No, my lord. That is all I'm saying, my lord. If
And your section 67 notice was of 2 months ago.
my lord, I had filed this anticipatory bail application. It did
But
not
you
come
took
up.
adjournment.
It did not come up, my lord.
You took
No,
adjournment,
on
sir.
one occasion I took adjournments because of improper instructions. My lord, grant me that.
Go and meet.
My lord, I will do that, my lord.
Produce the documents.
If any adverse report is obtained,
If any adverse happens, go and take bail. Finished.
my lord will cancel the anticipatory bail. My lord will not grant me the
No, why
anticipatory.
you are passing the brunt on to the court?
My lord,
It is
one-
your duty to go.
My lord,
You
1
cannot-
week, my lord, one.
No, no.
My lord, kindly, my lord. My lord, I have all the licenses, my lord. I am apprehending arrest, my lord. Kindly grants me.
Why are you apprehending, sir? 67 notice, go and
My lord, this is
comply.
an NDPS offense, my lord. Kindly considers that.
Then it becomes all notices issued. People will come to the court, give me anticipatory, keep the matter pending. Think over it,
My lord,
not today.
takes it up next week,
Take
any
it
day.
up. Sorry,
Takes
sir.
it up next week, any day. I have all the papers.
Next week, next Monday it will appear, but I'm not satisfied, sir. I could have passed the order, I could have recorded your statement, and I could have dismissed it. So it will be harmful for you. You better withdraw the application, go and meet with the investigating officer.
There is an apprehension, my lord, because my lord,
Sir,
9,000
that
bottles of
will be
Calcutta.
there. What can be done?
I have all the papers to substantiate those 9,000 bottles.
Talk with your client and come back next Monday. Yes. Mr. Chakraborty, give a set to him, Mr. Chakraborty.
Yes.
Please ascertain the technicalities. I do not know drugs.
We are already sent it to the.
I understand. I understand. You are the public prosecutor. You are our officer, na? Assist me. Yes, next one. Next.
Offense under section 448, 477, 323, 325, 379, 506, action for us,
What is the allegation?
Sir, there is a long-standing dispute between the parties. Our allegation is 1st of May 2025 at about 8:30 p.m. at night, all the accused persons being armed with deadly weapons had entered into the house of the informant and started destroying the household articles, and they also looted cash of rupees.
Yes, Mr. Chakraborty, who is there? Who is your other side? You are there.
No, madam, Mr. Chakraborty, Nida Chakraborty is there.
Not
Not to do. Yes.
I think 15 for the state, not I for the.
Yes.
But offense under section 448, 376, 511, 323, 307, 506 of the Indian Penal. Malad, in this case, Malad, what happened, Malad, the informant, the complainant, Malad.
My lord, before start, I interrupt, my lord. There is a mandate provision when the. So it's okay.
To
Intimation to the.
You have sent.
But it was delivered.
Take it.
He said.
Already, yes.
The duty may only to inform.
No, no, thank you. Incident of 9th August.
Yes, and FIR is Malad 19 August, after 10 days. First of all, but secondly.
You entered the lady's house and
Yes,
he
Malad,
assaulted.
can you see the FIR? Can you see the FIR?
Not
Actually,
anything.
what happened? But it was Malad. A city থেকে তো FIR kan দেখানো হলো। city থেকে তো FIR kan দেখানো। Malad, this complainant, Malad, is selling Malad illegal liquor in the local area.
Lady?
Yes, ma'am. Because I am raising a protest against such activities, for that reason, Malad, this complaint has been lodged after 10 days. Can you see there is an allegation of Malad injury? There is no injury, no medical.
No, no, where is what, this is by another person. This complaint against her?
But this Deepa Bhumi,
Uh-huh.
Deepa Bhumi lost the complaint, Malad.
Deepa, you are Animesh.
I am Animesh, Malad.
Deepa lodged a complaint against whom?
Against Animesh.
Animesh, yes. But
because
Deepa, against Deepa, he lodged a complaint earlier.
No, Malad. Actually, Deepa is selling the liquor in the local area. And Malad, this Animesh also resident of that area. He, earlier occasion, he Malad protested against such illegal activities for selling liquor. And to teach my lesson, well, this complaint has been lost. Can you see the FIR? Can you see the FIR and can you see the injury report and all this?
Where is the FIR?
After 10 days.
This?
Yes.
Tell now what is written. Yes, Mr. Jha, what is written?
May I read lordships? No.
You read na,
You are the defense.
আমি আপনার আমি
ইংরেজি 9/8/2025 তারিখে আমার স্বামীর অনুপস্থিতিতে ভোর রাতে
if is your that is better written, then you can
Yes,
read it.
yes.
That is better written.
Lordship.
Ajay, you tell us now what is the allegation.
Lordship, Ami Deepa Bhumi Shami Surendra, main allegation is your lordship that the petitioner had been to the house of that
Tried to rape her.
complainant. He has tried to.
For taking Malad alcohol.
No, that they are demanding that you allow me to consume alcohol. At that time, that lady refused, and suddenly he became furious and tried to commit rape. And on that event, the child was came. That time, child also beaten up. As this is the 161 statement also. So
What
it's
is
a defense story that
What
they
is
have.
the injury?
Lordship, there is
Then
no.
any medical kind.
No, there is no.
The lady subjected her to medical.
No, the victim
After
refused.
10 days, Malad.
Victim
So,
refused to.
Refuse medical.
Yes,
They
yes,
refused.
Malad.
It's true. Medical refused by the victim.
They
As
were
because-
residing in the same village.
But yes, it's in the same area.
See, investigation over.
And Lordship.
Charge sheet submitted.
No, my lord.
I stay outside the village.
Charge sheet not submitted.
Why not go and obtain?
Malad, this is
Surrendered
absolutely
and
false
obtained.
case, Malad. She refused medical after
No.
10 days of the FIR.
Refuse medical doesn't mean that nothing has been
After
happened.
10 days of the, if
Achha,
allegation
then
is so severe.
show us the injury report, Mr. Chakraborty.
Lordship,
But kindly appreciate one thing.
Are you a married person?
No,
She is married.
yes.
you're married having a one female child. My lord, may I hand it over to CD, my lord, from the every one sister statement stating that they are demanding to consume alcohol at his house, our house.
161 statement.
So this is not, if 161 has no value, then there is no questions of trial.
But why she lost the complaint after 10 days, there is no explanation. If allegation is so serious.
And the incident happened on the 19 August 25.
No, 9th of.
9.
9th of August.
9th of August 25.
After 10 days. Because I raised objection, but I was implicated in a false case. She is carrying on a business of illegal liquor, selling business.
Pending arrest, Mr. Guhul and advocate appearing for the petitioner submits. But why did she refuse medical, Mr.?
Lordship, sir, that no explanations in that CD, and I don't know what happened actually. But the others, they have stating that incident, which is.
Yes. Mr. Guhul and advocate appearing for the petitioner submits that the petitioner earlier lodged a complaint. Did you lodge complaint?
No, but that instruction.
Then how you are?
It's a very good defense.
That is my. But that is my instruction, after specific instruction, but I stated before your lordship.
You established that I have admitted, that's why I am implicating.
Admittedly, she is selling illegal liquor, that is admittedly,
How admitted?
But this, complainant.
But from the.
Why admittedly, why, how you are saying? A hard allegation is you went inside and you wanted a bottle of liquor.
If a person, for a sake of, person went to the house for liquor.
No, not demanding liquor. He want to sit and consume.
আচ্ছা হয়ে গেছে
No, forcing that's
submits that as not today. You're quite senior, sir, now. Dekhi da. You people behave properly in court. নাই আগেরটা যেটা লিখতে যাচ্ছিলাম এটাই Mr. Guhul and the advocate appearing for the petitioner submits that the de facto complaint that the de facto complainant that as the petitioner protested against submits that the de facto complainant was carrying on a business of illicit liquor. Objections to that effect were raised by the petitioner and as such he had been falsely implicated. Stop. The complaint was lodged about 10 days after the alleged incident without furnishing any explanation. In the said conspectus, custodial interrogation may not be necessary. Mr. Advocate appearing for the state opposes the petitioner's prayer and draws my attention to the statement of the witnesses as well as the inquiry, statement of the witnesses and other documents in the case diary. Hardly learned advocates having considered the materials on records. Stop. It appears that the de facto complainant refused medical test. He refused, no, Mr.
Lordship, sir. Medical. Lordship, sir.
Records, he wants.
Lordship, sir.
Having. He did claim mistake. Not that I and submits that there are strong incriminating materials on record against the petitioner, and as investigation is still continuing, no discretion needs to be exercised in favor of the petitioner at this stage. Having heard the learned advocates appearing for the respective parties, the nature and gravity of the offense, the role attributed to the applicant. Any injury report, nothing like that is there.
Lordship, they have produced, I did not find anything. Although they have sent it, Lordship, this is certified, and they're not.
And considering the gravity of the offense, the role attributed to the applicant.
Lordship, CD sent by the eyewitness, certified CD, Lordships, and some portion is not at all visible, Lordship. That's the original, but my lord, if you see the others contents, and the 160th one, that is not visible.
This appears to be Xerox.
Yes, Lordship. And this is not the original. They have only written the original CD in front of the.
But to the representation given, it says she refused medical.
Yes.
No. Gravity of the offense, the extent of complicity of the petitioner. I'm of the opinion that custodial interrogation may not be necessary. Allowed 10, however, his movement needs to be restricted. Allowed 10,000 to share rupees one local, subject to the satisfaction of the arresting officer with 482 condition below, with a further condition that the petitioner resides in the same address,
Yes,
from the shall not enter the jurisdiction of Hasidewa police station.
No.
Except for meeting with the investigating officer once in a week. Stop. The petitioner shall also intimate the present address where he would be residing to the investigating officer till investigation is complete for him. Yes, next.
Item number 16, next matter also 376, but I have served, but it was not effected.
আচ্ছা, ওটা এফিডেভিট অফ সার্ভিস as file be kept on record করে দেবো। দিয়েছো তো? Earlier affidavit of service you have not given?
Service done. My lord, kindly keep it on record.
No, item number?
Item number
15, previous.
Affidavit of service given?
He said ki I have already complied. Kindly keep it in record.
Next one, affidavit of service, as file, be kept on record. Next matter, service has not returned.
I have served, but it was not.
Ascertain and come back Monday. Yes, next.
Kindly give the direction to the state to serve to the IOM. I have served, but it was not effective.
Yes, Mr. Shoyi, please look into it. Next Monday. Yes, 17. 17. Not this week. Yes.
But I am not present, sir.
Mr. Guho, learned advocate appearing on the prayer of Mr. Guho, learned advocate appearing for the petitioner. The application is dismissed as not present. Yes. 18.
Number 18.
Not this week. 18 টা কি আছে? আসেনি কেউ?
Not sure, I am for the state in 18.
18 Deepankar Dev. Not here. Not this week.
No.
Yes, 19.
Number 19.
But I am for the state.
Yes.
But offense under section 498A, 326, 325, and 3 and 4 of the Dowry Prohibition Act. But about 3 years ago, marriage was solemnized.
13 years ago.
But that was wrongly written. Actually, 3 years. But can you see the FIR? I have an next page 40. That was my mistake.
Very good. Then what happened?
But allegation is that marriage was solemnized and there was a subsequent there is a physical and mental torture and for demand of dowry. On 4th of September 2025 at about 8 AM, the petitioner and along with other co-accused person abused the daughter of the informant. While she raised objection, she was assaulted. But that is the allegation. And other co-accused person were granted anticipatory bail by the learned session judge. Kindly see page 11 of my application. I have annexed the order.
Any overtake, Mr. Chakraborty?
Well, on the injury report is there. And the date of marriage was on 9th of March 2023. And the incident happened
after 3 years of marriage.
Within 2 years.
And FIR was 3 months.
No.
Yeah, 2.5 years. And
kindly see page 14.
The CS has been submitted.
Chachi submitted.
And kindly give me the liberty to correct the first item regarding date of the FIR. It was written, wrongfully written 5th of September. It should be 4th of September.
What is the injury? It's written marking of any injury not seen in the body parts.
Ashok, leave is granted. You are on record.
Yes.
Leave is granted to Mr. Ghosh, learned advocate. Sorry, Mr. Ghosh, learned advocate appearing for the petitioner to correct the cause title of the present application. So Mr. Guho submits that the petitioner has been falsely implicated pertaining to a dispute which allegedly pursuant to the alleged incident which occurred about 3 years after the marriage. The allegations leveled are omnibus in nature. The other accused persons have already been granted anticipatory bail by the learned session judge.
Kuch Bihar.
Upon investigation, upon completion of investigation, charge sheet has also been submitted, and as such further custodial detention of the petitioner may not be necessary. Mr. Chakraborty, learned at PPP appearing for the state opposes the petitioner's prayer and draws our attention to several documents in the case diary as well as the injury report. Having heard the learned advocates and considering the materials on record, particularly, the injury report, the nature of accusations and the extent of complicity of the petitioner. I am of the opinion that custodial interrogation may not be necessary, more so when upon completion of investigation, charge sheet has been submitted. Allow 10,000 to CODTs 1 lookout with other conditions of 482. Yes, next.
21, I am for the petitioner paying for only not.
Not today, next 21.
21.
Lordship, 21 and 31 are not today only. 21, 31. 1 day. 31.
21, 31, not today.
Fine.
No, 31, 31 you are opposing. Opposing? Oh, Tale. Acha, 21 not today, call the next matter. 22.
Not I am for the petitioner.
22.
But offense under section 448, 307, 34 of the Indian Penal Code and section 25 1A oblique 27 of the Arms Act. But petitioners are not the FIM active. There is suo motu complaint lodged by the police, but due to political rivalry, but this FIR has been lodged against this petitioner. Allegation.
Bullet injury.
Yes, Lordship.
Well,
But can you see that is, I am not the FIM accused. Can you see my involvement? Can you see?
what is the allegation against you?
One Rafiq was sustained bullet injury. He was admitted in the hospital. After receiving such information, police went to the spot and lost this complaint.
No, you are saying suo motu complaint?
Suo motu, yes.
Police authorities
Police
lost.
authority lost the complaint. Kindly see the FIR. I have annexed the FIR. Kindly see page 11 of my application.
You are not named in the FIR?
Yes, ma'am. Kindly see. I have annexed the formal part of the FIR, ma'am. Kindly see. 2 unknown persons.
CCTV, 2 persons entered.
And kindly see second paragraph of the FIR, ma'am. Another person also entered, madam.
Yes, Vishal.
Lordship, this is the 161st statement of the victim.
You did. Islam. Any recovered himself?
From them, there is anticipatory. Lordship. So, unless they are apprehended, no recovery can be done.
Complaint was dated.
Complaint, Lordship, 18/7/2025.
164 names Nurul Islam. Both has been named.
Lordship, Nurul Jamal Mia and Nurul Islam Mia are the before your Lordship.
Nur Islam is
Yes,
there in
yes,
the one for.
yes.
Nur Islam ও আর ওর শালা না
I am not the Shala. I am the brother. Brother of the Noodis. They are the
Okay, both are son of Chadder Ali.
Yeah, brothers.
Both are brother.
Abhisha, you see this?
Lordship, yes, I have seen Lordship. I have seen.
So Nur Islam, all right, but the other one, please check up if you get the name.
Lordship, the statements of relatives are there, page 18, 19, 20.
But may I submit one thing?
And
But in the second paragraph of the FIR, it was stated that the police came to the spot and talked to the local people, but none one identified that person.
Investigation is on.
This is the victim who has stated subsequently after being recovered from the
Relative, they are not the eyewitness. Victim is stated.
Person enters and
But if CCTV footage was were collected,
could not be detected. But what is the link of the other person?
Lordship, other person, Lordship, the statements are there, page 148. There 164 statement another.
148.
Lordship. Another 164.
Mood Islam ওটা শালা।
এবং now Lordship, I'll pray before Lordship to see page 53.
This is Nurul Mia's statement.
Lordship, the father of the VG, what he says, kindly go.
Did you go to the session, Judge?
Yes, Lord, this is stand on my application. Kindly see page 9.
Investigation still on.
On.
Apprehending arrest present, Mr. Guhol and the advocate appearing for the petitioner submits that the petitioners have not been named in the FIR. They have been falsely implicated. They have been falsely implicated. Stop. A suo motu FIR was lodged by the police authorities. Police authorities. Mr. Goal and the advocate appearing for the petitioner submits that the petitioners have been on the rudiments of a suo motu complaint lodged by the police authorities, the petitioners have been falsely implicated. Their names also do not feature in the FIR. In the said conspectus, custodial interrogation may not be necessary. Mr. Ganguly and the advocate appearing for the state opposes the petitioner's prayer and drawing my attention to the several documents in the case study, including the statements made by statements made under section. It is what 164 is now.
183.
183 BNS. BNSS submits that there are strong incriminating materials on record, and as such, no discussion, and as such, and investigation is yet to be completed. Having heard the learned advocates appearing for the respective parties, the nature of respective parties, and considering the statements of the witnesses, considering the statement of the witnesses, the injury report, the nature of allegations and the role attributed to the petitioners, I am not inclined to exercise discretion in their favor. More so when investigation is still continuing. Dismissed. Yes.
Both the petition.
Yes, next.
Item number 23 is time for the petition.
My lord, in this matter, nothing has been required from the possession of the petitioner. My lord, his name has been transferred from the arrested accused person, and my lord, charge sheet has already been submitted.
Yes, Mr. Chakraborty.
My lord, 97 bottles of cough syrup not seized from the possession of this petitioner. And 161 is there, page 18, which confirm the name of this petition.
Co-accused statement it has. Having heard the learned advocates in considering.
CS submitted.
Having heard the learned advocates and considering the materials on record, I am of the opinion that custodial interrogation of the petitioners is not necessary. When their names have transpired on the basis of co-accused statement, and since upon completion of investigation, charge sheet heard the learned advocates appearing for the respective parties and considered the materials on record. Stop. It appears that the petitioner's name has transpired on
My lord,
the
the
basis.
statement says that from the petitioner number 1, it was received and it was delivered to, it was supposed to be delivered to petitioner number 2.
And both are my lord brothers.
But by the person
By the
on the, it appears that the names of the petitioners transpired on the basis of the statement of co-accused persons and there was no recovery from the petitioners. Stop. In the said conspectus, the regards of section 937 of the NDPS Act are not attracted, and accordingly the application is allowed. And in view thereof, the application is allowed. Accordingly, in the event of arrest, it's 1 local 482. Allowed, yes. Next. Not today, yes, next.
25 lordship appear for the petitioner lordship. 25 lordship
appear. You are his junior. Are you not coming here?
Lordship, my learned advocate record is there, lordship.
Who is advocate?
21 matter.
Who is your other side? Who is your other side? Mr. Chakraborty here? Come tomorrow. Other side is not here. Case diary has come. Mr. Chakraborty, go through it now.
Let's take this out. Tomorrow.
Tomorrow.
Great, lordship.
Yes, next. 26.
Lordship, this application has become infructuous because during the pendency of this application, we had been.
So, on the
liberty to withdraw.
This court has been apprised that the petitioners have already been arrested. The petitioner, the learned advocate appearing for the petitioner submits that the petitioner has already been arrested. In view thereof, the application for anticipatory bail being such and such has become infructuous and is accordingly dismissed. Yes, next. 26, 27.
Madam, this is the last praying for 1 day accumulation.
Kano? Where is the case diary? You haven't gone through it?
Properly not.
Chalo, not today. Yes, next.
28.
28. Who is your other side?
28, my lord. Allegation under section 306
34
of Indian Penal Code, my lord. Charge sheet submitted, my lord.
দাঁড়াও না। যেগুলো নট ঠাকুর কটা হয়েছে নট 3-4টে হয়েছে বোধহয় না? আচ্ছা একটা দিন দিয়ে দাও তারপর ইয়েস।
My lord, allegation under section 306(34) of Indian Penal Code, charge sheet submitted. My lord, under section 306 of Indian Penal Code, my lord. My lord, allegation was that the de facto complainant stated that there was love relationship between the petitioner and the son of de facto complainant since 5 years. My lord, they agreed to get married. My lord, they roam in Durga Puja. After that, on 5/10/2022, the son of de facto complainant, after coming from the immersion, the petitioner called him and they have a, my lord, discussion. After that, what discussion had happened, the de facto complainant has no knowledge about that, and after that, coming back to his home, he committed suicide. This is the allegation. My lord, actual fact of the case is that there was never a love relationship between the victim girl and the present petitioner. My lord, I am submitting the certified copy, my lord. The present petitioner has already lodged, my lord, case against this victim under section 354, my lord.
When was that? Was in 2022.
Before.
Yes.
Before, my lord. Yes, ma'am.
Uh-huh.
Before, my lord, the present petitioner has lodged a case against this victim under section, my lord, 341, 354, 509, 506. My lord, after 2 months, he committed suicide. My lord, I am placing the certified copy, my lord. My lord, she is a student, my lord. My lord,
She lodged a complaint, she lodged a criminal case 354 in 2022. What happened in that?
my lord,
Anybody was arrested?
My lord, he prayed for bail. My lord, bail was granted. My lord, trial.
No, 354 was lodged.
My lord, I am placing the certified copy.
This Pia Paswan lodged the 354. Allegation is against
This present petitioner and his father. Present de facto complainant and his son.
Where is the complaint?
Page number 9. My lord.
So who lodged the complaint? The father of the
victim. Manoj Shahan.
This cannot be read. Can you read this FIR? I cannot read this. Yes, Mr. Chakraborty, what is there?
My lord, the case is initiated on 2022.
That was the first case.
No, my lord, this case.
First case and
This
second case
FIR
both.
dated on 7/10/2022. So kindly consider the conduct of the accused person and charge sheet submitted. So trial will be visited. Hand is already.
So
7 witnesses is there.
No,
And death
this-
is due to the hanging
Yeah.
antemortem non-continuous ligature mark. 306 is
suicide.
Non-continuous, and charge sheet is submitted, and case is initiated from 2022 too.
No, this is. Oh, but the
7
on the basis of one complaint, 2 cases initiated.
No.
This you are coming for anticipatory bail in connection with a complaint of 2022.
My lord.
Yes.
My lord, initially what happened, my lord, this present victim forced the petitioner to have a love relationship with him. My lord, she refused, my lord, and she had lodged a 354 case. My lord, then he committed suicide. Then his father has lodged a complaint against this petitioner.
When did he commit suicide?
My lord, he committed suicide 5/10/2020.
5/10/22.
2022.
And FIR has lodged on 7/10/2022.
So after 3 days, the complaint was lodged. And this case was
Prior.
Pardon?
Prior, man. Prior to this one.
Not with this alleged incident.
No, prior, my lord, this.
Prior to suicide, prior to the incident, Pia lodged a complaint against this gentleman who committed suicide alleging 306.
No, 354.
354, sorry.
My lord.
Now, in that, what happened?
My lord, trial commence. My lord, he has taken bail, my lord, this
And
present.
Mr. Chakraborty, check up and come tomorrow. Give a copy to Mr. Chakraborty.
Yes.
Yes, next.
That-
Not today or day after tomorrow.
Day after tomorrow.
Day after tomorrow.
Copy টা একটু দেবেন?
Please give a copy to Mr. Chakraborty.
Day after tomorrow, কত তারিখ হচ্ছে? 17?
হ্যাঁ।
No, yes, yesterday fixing.
Tomorrow?
Sorry, tomorrow, my lord.
Great.
Or next week then?
No, my lord, tomorrow. Great.
I know 29.
My lord, 29 one day tomorrow.
Yes, next.
30.
Oh, sorry. The Charter NDPS Act, take over the paid from the court to statement of no CDR or the bank transaction shows the involvement of the present petitioner is also implicated in the present case.
Why did you withdraw? Why did you withdraw the earlier application?
Because it's withdrawn by some, because there are some exceptions taken for that. Withdrawn.
Yes, sir. Who accused?
Who accused?
Who accused? Charge sheet submitted.
No, ma'am.
Charge sheet not submitted. No recovery from him.
No, one Subroto from Sushanto Sarkar, my lord, the contraband was recovered.
Even though
So you have to, investigation still continuing.
Continuing.
So you meet with the IO. Mr. What's your name?
Abhishek Singh Lawson.
Mr. Singh Learned Advocate, what I apprehending for this. Mr. Singh Learned Advocate appearing. What are the upure likhe dao na? Mr. Singh Learned Advocate appearing for the petitioner submits that the petitioner has been falsely implicated. The regards of section 37 of the NDPS Act are not attracted since his name has transpired on the basis of co-accused statement. Such content and expert. Mr. Sarda enters appearance on behalf of the state respondent and draws my attention to the court, draws the attention of this court to several documents in the case diary. Stop. It appears that there was no recovery of contraband substance above commercial quantity, contraband substance from the petitioner, and that his name has transpired on the basis of co-accused statements. In such circumstances, custodial interrogation of the petitioner may not be necessary. However, his movement needs to be necessary. Accordingly, allowed 10,000 to CODTs, 1 local, 482 conditions gulu, with a further condition that the petitioner shall meet with the investigating officer once a week till investigation is complete. Allowed. Yes, next.
I have 31.
How about the statement?
Not this week. Yes, next. 31 need to file the wait. 31 need to file the বলেছিল ও আচ্ছা আচ্ছা 31 not today করবো yes হ্যাঁ হ্যাঁ yes yes next
Level 32.
no one not this week yes
33. But the day after tomorrow. Yes.
Monday yes next
34.
Monday
35.
yes
Number 30. My name has been transferred from the co-accused. And
Right.
nothing has been recovered from my position. That has been only the co-accused statement.
Mr. Chakraborty
My lord, 100 gram brown sugar has been seized by the co-accused, principal accused. He is arrested from the spot. And from the statement of the principal accused, the present petitioner name has trespassed.
very good now charge sheet
Charge sheet, my lord, charge sheet submitted.
আচ্ছা
Chemical examination report and episode of the firearms is pending.
30-তে চার্জশিট সাবমিটেড বলেছিলাম তো? এখানে ওইটা ঢুকিয়ে দেবে মোস্ট when upon completion of investigation charge sheet has been submitted. How many petitioner? One. লিখেই নাও ঝামেলা মিটে। The learned Mr. Sergeant learned advocate appearing for the petitioner submits. ও তুমি বসিয়ে নিতে পারবে সেম। এইটাতে শুধু নোট রেখো চার্জশিট সাবমিটেড। Allowed.
Itself today, my lord, as per my
Till date.
till today is charge sheet submitted. Today.
Charge sheet has been charged last the only Mr. Sergeant learned advocate appearing for the petitioner submits that the petitioner has been falsely implicated. No contraband substance was recovered from the petitioner and his name has transferred on the basis of two accused. Mr. Chakraborty learned advocate appearing for the state submits that upon next paragraph, Mr. Chakraborty has drawn the attention of this court, submits that upon completion of investigation, answering our query, Mr. Chakraborty learned APP appearing for the state submits that upon completion of investigation, charge sheet has been submitted today. In such circumstances, in such circumstances, and as there had been no recovery of contraband substance from the petitioner, and as his name has transferred on the basis of co-accused statement, I am of the opinion that the regards of section 37 of the NDPS Act are not attracted, and accordingly the application, and accordingly custodial interrogation of the petitioner may not be necessary. Allowed 10,000 Pushi rupees, one local. Allowed. Yes.
Good.
Next.
Item number 33.
Next week, Monday. Yes, next.
37.
Petitioner, Mr. Chakraborty, you're there. 37.
Nilo Chakraborty is there, my lord. No, 37 Yes.
Yes, tell us.
My lord, one day ago, one said.
Then day after tomorrow. Yes.
Day after tomorrow.
38. Not there. Not this week, yes. Eh? Not today. Who is there? Mr. Chakraborty?
Yes, Mr. Roy is there. Dr. Roy.
All right, not today, come ask him. Yes, next.
40.
Not this week.
41.
Ready? 41. No one for this state. Monday. Then it would not be dismissed. Monday, then we can go. Not today, Tati Doctor Vankias. Not today.
41. 42.
Next week. Next week. Not this week. Yes.
43.
43, Lordship, and for the petitioner.
Yes.
Service affected.
Service affected.
Collect the CD 1 day accommodation, just 1 day. 1 day accommodation.
All right, not today. Dako, next. 44, who is there? Not this week. Yes, 45.
5.
Who is for the petitioner? 44?
I'm from the state lordship one day accommodation, lordship city not procedure. Ask the lordship, tomorrow lordship city must be put.
Not today, yes.
45.
45. 44 was not today. 45 who is for the state. Again, it gets stacked up, no?
Tomorrow.
Not today. Daku, 40.
State. I don't know the petition.
Who is your other side? You're there. Ready? Ready? You're for the state.
For the state.
Yes, tell us what is the matter.
During the Monoshopuja night, the victim along with his friends, the group of boys, they went out and allegedly the friends demanded some money for drinking purpose, and ultimately he was refused and beaten up by the friends. Then afterwards, this case started. The previous act is section it appears from section that previous allegation is there, but I have instruction, but there is nothing like that. The injury will stay.
When was the complaint lodged?
Complaint lodged, madam?
August 25.
No one.
23rd August. Yes, sir.
Oh,
CD, where is the CD?
Injury.
Investigation completed or?
Charge sheet not submitted.
Charge sheet not submitted.
Operate, ma'am.
My lord, injury in head and chest and earline fracture is there.
Well,
Hairline fracture.
Hairline fracture is not, dislocation
Oh,
is.
really?
My lord,
That is nothing.
no, that's it, that is, oh.
You
my
get
lord,
a
I-
hairline fracture and find out what will be the pain.
My lord, I apologize, my.
Have you suffered hairline fracture?
Suffered, but it's very painful. My lord, I agree, my lord. But it should not be lightly taken, my lord. Actually, my lord, my junior brother's fast brief. That is why I was shouting more.
He has been asked not to carry heavy weight. Advice. Doctor has advised him, don't take heavy weight, you are injured. Where is the statement of the injury?
Statement.
Where is the statement of the injured, sir? Is it here?
No, you're in.
Will you check it up? Will you check it up from here?
That's page 7, 9 and
Page 7.
11, there is a 161. Page 7.
Victims.
No.
Statement of Surajit Das. Who was beaten up? Surajit Das. Whom did you beat?
Surajit Das.
Surajit Das.
Surajit Das is the victim.
Surajit Das. Surrender and obtain bail.
Kindly consider, we'll cooperate, my lord.
No, you surrendered.
My lord.
There was an incident. He
There was,
suffered.
maybe, my lord, there was an incident. I will cooperate, my lord. I'll cooperate, my lord.
See
Kindly
the
consider.
injury reports.
To attract, my lord, under 18, there must be dislocation, my lord. There must be dislocation of bone.
And hospitalization for grievous hurt.
20 days, my lord.
Apprehending arrest presented. Submits that the petitioner has been falsely implicated. Falsely implicated. The allegations labeled are omnibus in nature.
You'll cooperate, my lord. Kindly consider.
Omnibus in nature, and in the said conspectus, the petitioners may be, and in the said conspectus, custodial interrogation may not be necessary. Learned advocate appearing for the state opposes the petitioner's prayer. Having heard the learned advocates and considering the materials on record, the statement of the victim, the injury report, and the extent of complicity of the petitioners in the alleged offence, I am of the opinion that custodial interrogation may not be necessary. However, the movement of the petitioners need to be restricted. Allow 10,000 2 CODTs, 1 local, 482, they shall not enter the jurisdiction of Pundibadi police station. 7, except for meeting with the investigating officer of the case. Once a week till investigation is complete, the petitioner shall also immediately intimate the address where they would be residing to the investigating officer. 482 conditions allowed. Yes.
Obliged, Lord.
ওনার এটা ওনাকে ফেরত দিয়ে দাও। Not today. 48.
48.
Who is your other side? You're there. You're there.
48, that's a 1 day accommodation.
The half century করে না যাচ্ছে।
49.
Next.
49, and for the petitioner, I have not placed this application.
আচ্ছা, on the ভালো কথা বলেছে। On the prayer of the learned advocate appearing for the petitioner, the application being, application, we will revive that. You want to do?
Just
Dismiss-
record my name.
Dismissed as withdrawn. Or we will say not press, same thing.
Same thing, no,
Dismissed as withdrawn. Yes, next. Give your respective names. Item 50 Daco.
Item now 50.
Who is your other side?
Can you make it not forever?